Your Lordship, may I be permitted to mention a matter for seeking your Lordship's kind leave to.
Chamber matter?
No, no, not a chamber.
Mention after the chamber matters.
It's item number 26 matter taken here.
I am for the plaintiff. Some of the defendants have filed an application for dismissal of my suit before goes to trial.
G11.
G11.
Whose application?
I am also
Mr. Obrojit Mitro's application, yes.
but I am also appearing for one of the defendants. Let the plaintiff and applicant makes a submission, then I have
In a partition suit, he is asking for dismissal, rejection.
This application is to be heard of.
Yes, has to be. Has to.
Lordship is fixed
Yes.
10:30. Appearance is complete.
Yes.
Kindly hear this application.
Here, Mr. Obrojit Mitro.
Number 38. I am interested. One of the sons.
Oh, one of the sons.
Now the suit has been
Both sons
converted.
are not with the mother.
No.
One son with the mother.
Yes. You are the other one.
With the
But the
brother-in-law.
suit has been converted to a partition suit. So everybody is interested. Now, how order 7 level lies, Lordship would pull out to here, Mr. Mitro. And I have brought the latest judgment on this.
Yes.
Give me.
No.
Share
You
with
just
me.
argue, you just argue.
You're flaunting latest judgment. Let me know.
He's
But you
flaunting.
argue.
He's flaunting. You argue. You are the latest. He's the greatest, but you are the latest.
Yes. What is your stand with regard to the suit?
The suit is miserably misconceived, barred by law. But you kindly takes a look at the plaint. The plaint though.
It's annexed in your
It's
application.
annexed without the annexures. So if a separate plaint copy is there, then it is.
Which page?
Amended plaint is there. If your Lordship can. Plaint আছে?
Let me see the annexures.
Very well then let me go by annexures. My advocate record has not made copies of it. The plaint starts at page
83, technically, the body of the plate.
page 83. The Lordship, may I start with the cause title? It's a partition suit.
Page 21.
Page 50.
Page 83.
No, but that's the body. But I must show the cause title. That's the best part. Page 55. Suchandra Bhutoria. Page 55 is the plaintiff is Suchandra Bhutoria. And wife of late Arun Kumar Bhutoria. I will presently show, my lord. This is for partition of Arun Kumar Bhutoria's estate. The first defendant is Anil Bhutoria, the brother. He wants to partition with Arun Bhutoria's brother, Arun Bhutoria's estate. Then defendant number 2, Sandeep Bhutoria, some common surname. Then it's a very interesting part. From number 3 up to number 34.
That is page 57.
57. The third defendant.
That is the limited company.
Yes, so his co-owners are limited companies, her co-owners. This is the first time I'm coming across a plaint where a human being has a co-owner in a limited company. So that's why I'm saying there are around 30 limited companies who are, I suppose, some relation. Now, because co-ownership partition with limited companies. Now, Lordship, what is the cause of action? Lordship, can you take a look at the cause of action? Say something.
Yeah.
I don't want to.
You are saying, how can I say it?
The cause of action, Lordship, we will be finding at paragraph 51B. Lordship, may I come straight away just to show what the second volume of the petition. Sorry, it's the first volume. Yes. Para 51, this is page. This is is that the way this is sorry, paragraph 4. Paragraph 40 capital A. Paragraph 40 capital A of the plaint. Yes, my mistake. It is at page 124.
127.
125. 125. Kindly come to page 125 of this application.
Yes. Para 41,
Oh,
44.
40 to 40, did you see page? So kindly see the reverse. Page 127, the amendment is there.
Yes, which is allowed. For which you have not.
Under the facts and circumstances, it shall be evident that the assets and properties mentioned in Schedule E to the plain belongs to late Arun Kumar Bhutoria. After his death, the said assets and properties had devolved upon the plaintiff and the defendant, number 35 to 37. Now, kindly take a look at Schedule E. Lordship, that is separately in the plaint. Lordship takes a look. The plaint I thought would be here in court. Lordship kindly takes a look at the. May I hand up a copy of the plaint? That is Schedule E is what they ask for. And this is what they ask for partition. First page issue, Schedule E issue, first page Schedule E. Schedule E,
Schedule 1, I.
one of annexure.
Yes, annexure.
The person is office at Elegant Towers.
Yes.
The bracket is the owner, Sunshine Developers. Office at Elegant Towers. Bracket Amazing Builders. Now she will go through all the properties here up to it is 3 pages. But for paragraph 50, but for 15, 1 to 14 are properties of companies.
Okay. So up to
1 to 14, then again 15 on, then again 16 onwards.
15 are the properties of the limited companies.
And 16, 17, 18 is also property of limited companies. 16, 17, 18, 21 are belonging to limited companies. Now, no paragraph, yes. Now 10 is one more, not the companies as per their description. 10 and 12.
10 and 12.
They claim Arun Bhutoria's property. Now, barring 10, 11 and 15, none of the other properties seem to be properties belonging to late Arun Bhutoria. Serial numbers 19, 20 are meant for a Sherlock Holmes novel. He has to find out which are the 20 katas in Barupur which is in issue.
And I've got land in Baripur. Tell me which.
And yes, number 13 also, land in Uluberia. Uluberia, 2,400 kata.
Near Ruby Hospital, 5 acres.
Yes,
So, Abhijit,
near
that
Ruby
land-
Hospital, 5 because it could be, it will be a it's very interesting to find out what is this 5 bighas near Ruby Hospital. This could be High Court, could also be near Ruby Hospital. So my lord, near Ruby Hospital, then paragraph 19 is Baripur 20 kata.
I don't see any humor in this.
It's always good to be humorous rather than.
No, you are by nature humorous.
Okay.
You are
19.
born humorous.
Service tax paid to
Then, my lord, page
9.
Everyone looks at
Serial
you,
number
have to
19.
laugh.
19. 19 is Baripur. Lordship has got it. Serial number 19.
Yes.
Page 71 of the plaint.
Yes.
That is Baripur.
Yes.
20 katas. Where in Baripur? It's going to be very nice. That goes against order 7. I'll place the provision when you give a property, if it does not give the description, plaint is bad. Then, so companies' properties, my first point. Now, may I go back to the plaint? And they've asked for partition of this. Kindly looks at the prayers in the plaint. The prayers in the plaint are in volume 2. Your volume. ওটা কি? Volume 2 বার করো তো, volume 2 বার করো তো। এই, Yes, the prayers start at page. Oh. Prayers start at page 157, next volume of the application.
Yes, 157.
But I am concerned so far as annexure E is concerned, that is prayer A and AA. Decree declaring that all the properties and assets, including different numbers 3 to 34. So assets in, so they want to partition 3 to 34. Companies they want to partition. And those mentioned in the schedule, kindly, and those in the schedule, at page 161 it continues. Annexed T being annexed here to being annexuary are the properties and assets belonging to the plaintiff's husband. So the companies are personal properties of human beings. Then prayer AA, page 159. Decree for partition of the assets and property mentioned in the schedule being annexed E hereto among the plaintiff and the defendant number 30 or 39 according to the shares of the said parties. So the company's properties will be partitioned, and the first prayer is declaration that these companies are part of the belong to the plaintiff's husband. Now, Lordship kindly comes to the interesting part. Kindly comes to the second prayer at page 159, which I will go to pleading presently. AB. Decree for declaration that the equity shares, particulars whereof have been given in Schedule A2 hereof, are properties and assets belonging to the plaintiff's husband. And decree for partition of the said shares mentioned in Schedule A2. Now, may I come to the pleadings back? What is A2? Page 127. I will come. I had placed from 127, para 40, capital A. Enjoyable claim, actually.
After that, you are doing it is more enjoyable.
Page 127, para 40B.
You are doing it is more enjoyable.
Yes.
I have to see from
Page 127, para 40B. The
Amended portion.
Yes, I mean, this is where the cause of action is, what they're seeking to partition. The plaintiff states that some of the assets and properties were in the name of late Arun Bhutoria, including shares which were standing in his name in several of the companies which were owned by him. However, some of the properties and shares which have been described in Schedule E were standing in the name of defendant numbers 1, 2, and 38. And they are holding the same as a trustee for the benefit of the heirs of late Arun Kumar Bhutoria. I will go to the other pleadings also. This is barred by law. I will place the Trusts Act and the judgment. Trust cannot be oral. It's barred by Indian Trusts Act and various judgments. Trust has to be registered, in writing, registered, whether it's movable or immovable, or by transfer of properties. So it is not the pleading that Arun Bhutoria transferred the shares to them. Now, I will show the other pleadings also. The defendant numbers 1, 2, and 38 were at all material times standing in a fiduciary capacity by reason of the relationship of confidence enjoyed by the defendant numbers 1, 2, and 38 insofar as Arun Bhutoria was concerned. My property becomes I become a trustee of my property because I am very close. I have shared confidence or relationship, confidence with the Shomrit Sen. So my properties become, I hope my personal properties become trust properties. The properties which were in the name of defendant number 1, 2, and 38 are all impressed with constructive trusts, totally barred by law, and are held for the benefit of heirs of late Arun Kumar Bhutoria. The plaintiff states that several of the properties are standing in the names of defendant number 3 to 34 limited companies. The shares of and in the said defendant number 3 to 34 were almost to the entirety held by Arun Kumar Bhutoria, comma, defendant numbers 1, 2, and 38. And by way of cross-holding between defendant numbers 3 to 34. The particulars of shareholdings of defendant numbers 3 to 34 will appear from a schedule annexed hereto and marked A2. The aforesaid manner of cross-holding of shares is evidence of the fact that the defendant number 334 were in the control of Arun Bhutoria. Let's take a look at annexure A2. Lordship, kindly come to that volume which I have given, annexure A2, page 51B of that of the amended plain copy I had handed up to my Lord's officer. Lordship, on B, page 51B is annexure A2.
Yes, 51B.
Is it
A2.
A2? Yes, my lord. Lordship takes to the first company, AK Computech. What is the defendant number? That AK Computech is defendant number. I'll just tell you, Lordship. My lord, that is defendant number 3. Anil Bhutoria, that is defendant number 1, holds 9,900 shares. Arun Bhutoria, 100 shares. I have made the argument that these are also incorrect, but then I can't go into. I have to go by demurrer today. I have to go by demurrer. So, with 100 out of 10,000 shares,
Yes.
then next one, defendant number 4, AK Foundations. Arun Bhutoria 100, Anil Bhutoria 1,99,800. Kanta Bhutoria 100. Then Ashray, defendant number 5, Arun Bhutoria is 5,100 out of possibly 8 lakhs. Then APCON. There he is claiming to have Arun Bhutoria 1,54,000 shares. Slightly more than 50%. No, not 50% because the share capital is possibly around 4 lakhs, so 30%. Then next is very good.
Shareholdings by these 4 persons.
These 4, including a company, Gangadharam.
No. This APCON.
APCON, Lordship,
These 4 persons.
4 persons and then kind
there is
one more. A company holds, another company holds.
So the others are only these 4 individuals.
Yes, and one Gangadharam holds 1,87,000 shares. Gangadharam party, দেখো তো add করেছে কিনা দেখো তো Gangadharam is a third party. third party holds majority shares in this company. Then Al-Qaetan, that is defend number 7, 51C. Arun Bhutoria does not even have a share. Then Akla Builders, defend number 8. The Shubham party, देखो तो Shubham party है क्या देखो तो. Now, Lordship, can see the shareholders, Akla Builders, Arun Bhutoria 67,000, Anil Bhutoria 67,000, Kanta Bhutoria 10,000, and Shubham. I don't know, he's not a party. That party has 1,25,000 shares, the majority shares. And this way it goes on. I'm sorry, I should not be frivolous, but then this plaint just is not something which I can take very seriously. Unfortunate that in our High Court, this kind of a suit is there. And when our High Court has repeatedly held, division bench, different courts, that you cannot ask for a partition of a company's properties. Number 1, company and the shareholder are separate, Bacha Gazdar. Shareholder has no right in the company's property. Schedule E is all company's properties. Then shares belonging to another individual.
Representing any limited company?
No, I am representing defend numbers 1 and 2.
1 and 2.
But I am by twofold. I am asking rejection of plaint outright because this is a misconceived suit on 3 grounds. One is barred by law, Companies Act. You are a shareholder is independent. Her company is independent. Suit for partition of company's assets is inherently bad. Coupled with the other prayers that these companies belong, because otherwise, unless prayer,
Shareholders are all family members, not outsiders.
some companies are also shareholders.
Companies are all.
I will show judgments where family members only file a suit for partition of company's assets. In fact, I was this unfortunate draftsman in my very junior days of a plaint where much stronger case, 100% shares held by 4 brothers. Unlike here, other companies holding shares also, majority. And it was a partition and injunction. Our division bench held, so far as partition and injunction regarding companies' assets are concerned, it cannot be. It's barred. Other judgments also many. However, even if it's husband, wife, even if it's father and son, father, son, wife, if there are 3 shareholders of a company, you can ask for partition of all the shares which are standing in the names of the co-owners. So the 3 brothers inherited shares from their father, together 100% shares of a company, company B. One of the brothers asks for partition if it's a mitakshar. So then there can be, I am a co-owner, partition the shares amongst us, but not the company's Chodungi property and Theatre Road and Park Street property. Number 2. Now, number 1. Number 2.
That is property standing in the name of the
Company, and that is their case. That is the whole basis of their case. Defend number 3 to 34 is a part of the estate of the Arun Bhutoria. That is the companies. It's inherently misconceived. I feel embarrassed when I look at that plaint and when the division bench had delivered the judgment. And because, but it was my very junior days, so I can still excuse myself. Here on now yes, actually, I feel embarrassed to make submission of this nature in our suit or in the original side of our High Court. Next, shares standing in the name of somebody else, brother. It is not a case of Mitakshara HUF and a co-personary property. It's a case of somebody holding the shares because it's a fiduciary relationship. So it becomes a trust property. Firstly, brothers do not share fiduciary relationship. Even if he does, a banker and customer is a fiduciary. So my banker is Standard Chartered Bank. So all the assets of Standard Chartered Bank are held in fiduciary capacity for me. But Indian Trust Act lays down how a trust can be created in this country. So just by I repose faith in you, a trust cannot come into existence. So this whole case is based on one, the 3 to 34 are part of Arun Bhutoria's estate. All the assets of 3 to 34 are Arun Bhutoria's personal property. So you ask for partition.
These properties are standing in the name of the
Companies.
company.
Limited company. So my first suit is barred by Companies Act and all the laws. Second is barred by Trust Act.
So this is your case in your.
Number 3 is misjoinder of parties and cause of action. It is a case of multifariousness.
That's a different issue. Regarding misjoinder and non-joinder, it is not so fatal. But
well, non-joinder is not fatal.
Definitely.
Yes. And misjoinder also, then the names have to be struck off. Has to be struck off because names have to be struck off because I don't want my suit, my partition suit, in my partition suit, somebody else being a party. Number 3, what is the cause of action against me? Defendant numbers 1 and 2. 2, there is no. 2, firstly, there is no relationship also. There is not a brother, not a cousin, just a common surname. So why have I been impleted? The co-owners, according to them, are plaintiff and the defendant numbers 37 to 35 to 37 are the co-owners. The plaintiff and defendant numbers 35 to 37. See the prayers, that is the prayer. Partition between plaintiff defendant numbers 35 to 37. Why is anybody else a necessary party? You file your suit, do your suit with, if you want to, whatever assets are between each of you, I have nothing to say. Take me out, take all the companies out. But this suit, as it is framed, is misconceived. May I show some more of the pleadings? Now, kindly come to prayers. Yes, sorry. Prayers at page 161.
Your application, volume 2.
No, my lord, yes, volume 2 it is there, or that plaint which I had handed up to my lord, the amended plaint, Lordship, whichever. Page, my lord, page 161. No, sorry, 159, 159. There's a reverse page.
Yes.
I had placed AB. Equity shares are as it belongs to the plaintiff's husband. My personal shares, another company's shares. The shares belonging to a third party company. Because personal asset of. Next is AC. Decree for partition of the said shares mentioned in Schedule A2. Okay, kindly take for a minute the Schedule A2 which I had handed up to my lord, page 51B. Kindly take a look. Kindly take a look at third party company. Let's take the case of APCON, that is at page 51B. They want the partition of the shares of APCON, page 51B. Defendant number 6, APCON. Who are the shareholders? They want to partition the shares. The last shareholder in on the next page. 51B. 51B. Last name is APCON. 51B of the amended plate, of the amended plate. APCON, got it? That is defend number 6. The second column is they want to partition the shares. Shares of Arun Bhutoria 1,54,000, Anil Bhutoria 95,000, Kanta, Anil Bhutoria defend number 1, Kanta the defend number 35, Sandeep Bhutoria, and now you come to the next page. The last shareholder's name is in the next page. Gangadharam has 1,87,000 shares. So they want to partition the shares of Gangadharam also, who's not a party. Similar way, Lordship, can you see? Next take Aikyatan.
Yes.
That is defendant number, I think 7 or 8. Sandeep Bhutoria, defendant number 2. Dilip Kumar Bhattacharjee, he's not a party. He was to partition the shares of a third party, Dilip Kumar Bhattacharjee.
Is it a shareholder?
Yes, Dilip Kumar Bhattacharjee is simply. And what is the prayer?
Of this company, simplicity.
And the prayer I'm third party.
Shareholder.
And I'm reading out the prayer. Decree for partition of the said shares mentioned in Schedule A2. That is prayer AC at page 159 of the application. No, not here. That is the prayer for partition of all these shares. They want to partition my shares. Firstly, then Dilip Bhattacharjee's shares, Gangadharam's shares. So many third parties. Now, number 1 is third parties. Number 2 is I, defend number 1 and 2. Why should my shares be partitioned? Arun Bhutoria has passed away. His shares can be partitioned. I understand. I have nothing to say. Arun Bhutoria, I'm not a legal heir of Arun Bhutoria. It is rightly plaintiff and defendant number 35 to 37, the legal heirs.
You are defendant number 1 and 2.
1 and 2. I'm not a legal heir, admittedly, that is their plaint case. Yeah. Then kindly may I come back to the prayers, my lord? That is at page 159 of the application. Prayer BA. Prayer BA. Paragraph 48. Paragraph 48. Volume 2. BA. Decree for partition of all properties, assets, and business as may be found due upon such inquiry amongst the plaintiff and defendant number 35 to 37 in accordance with shares of the said parties as stated in paragraph 48 of the plaint.
Page 133 of the application.
Again, look at paragraph 48. Page 133. Paragraph 48. Upon inquiry, the plaintiff has come to learn that various instances of mismanagement in the affairs of the companies and or the firms as mentioned in schedule being annexed E herein has been undertaken by defendant number 1 without any authority after the demise of Arun Bhutoria in the manner as follows. Meetings of the company. So they want an inquiry into this.
Mismanagement, affairs of mismanagement.
Company
affairs of the
affairs.
company.
Yes.
Affairs of the company.
Meetings of the companies and firms as stated in schedule being annexed E. Then prayer B, various directors and additional directors have been inducted and the shares have been increased. How can there be an inquiry into all this? A, B, C, each and every one of them pertain to companies' affairs, companies' assets, companies' shareholders. Lordship has dealt with section 430 in many cases. Totally barred. It goes on up to A to H, up to page 141. Kindly come to page 141 then. After these mismanagement and language also absolutely copied from section 241 of the Companies Act.
Operation mismanagement gets 50% share coverage হতে ওদেরকে না consult করে করছে।
সবকিছু, everything is operation. 241 language has been quoted.
41 case later.
It's entirely 241 case. Then can you see page 141, para 49. The defendant numbers 1 and 2 are also refusing, page 141, para 49. The defendant numbers 1 and 2 are page 141 in the application.
Yes. Para 49.
Para 49. The defendant numbers 1 and 2 are also refusing to disclose any papers of the business of the plaintiff and has taken over control of all the companies and firms as mentioned in schedule. In the schedule being an exterior are the properties belong to company. Upon inquiry, the plaintiff has also come to learn that the defendant number 1 himself and or through his agents and or nominees and or his authorized signatories is operating the accounts of the said companies and firms. The plaintiff's apprehension the defendant 1 is seeking to alienate the usurp the funds, assets, property of said firms and companies. This is companies' affairs, 430.
These reliefs are not sought in a partition suit according to.
None of this.
Because of
Barred by so many laws, so many laws. Companies Act, Trusts Act, then
holding shares on behalf of another
CPC, Benami Transactions Act. I will show each and every one of them bars this provision, bars this case, apart from several judgments.
shares
No.
held in trust. It's para 12 with specifically
Now I'll show a few more pleadings from the plaintiff.
12 with
Kindly come to no, आगे देखिए आगे वो अच्छे आगे वो अच्छे
HUF to the HUF now para 1. But it's not an HUF, so there will be no exception made out of it.
It is not a co-parcenary case. I will just now show my see paragraph 1 and 2. Not a co-parcenary, not a co-parcenary property where and Mitakshara HUF, because this is self-acquired property. That is this case. Kindly see paragraph 1 of the plain. Page 83. At all, page 83, paragraph 1 and 2. Just to
Yes, page 83.
paragraph 1. At all material times, Arun Kumar Bhutoria, the husband of the plaintiff, was a Hindu governed by Mitakshara school of Hindu law. Up to that is fine. Till the period mentioned hereinafter, the plaintiff's husband used to reside in a small apartment flat at 120 Mahatma Gandhi Road. Then 1A to 1B, that is next page. 1A, 1B টা কোথায়? 1A to 1B টা কোথায় আছে? 1A to, oh yes, yes. Page 81. Page 81. One page earlier. Page 181, what is paragraph 1A and 1B? The plaintiff, the defendant number 1, defendant 35 to 37 are related to each other. You got it? The defendant 35 is the mother, defendant number 1 and the mother of the defendant number 1 and the mother-in-law of the plaintiff. 36, 37 are the sons of the plaintiff. Defendant number 2 is not related. Kindly notes, defendant number 1 is related. Our sons, the relationship between the plaintiff, defendant number 1, 35, 37. Now, paragraph 1B. The defendant numbers 1, 2, and 38 are the ostensible owners of various shares. Comes Benami Act. Are the ostensible owners of various shares in the defendant numbers 3 to 34, forming the AK group of companies which are held by them as trustees and for the benefit of late Arun Bhutoria. The plaintiff and defendant 36, 37. Now coming back to where I was, page 83, paragraph 2. Paragraph 2 seals the case of co-parcenary. In view of the fact that the father of the late Arun Kumar Bhutoria did not have adequate financial means, the said Arun Kumar Bhutoria, Ashokali comes to page 87, the plaintiff's husband was compelled to work at a very young age. So no co-parcenary property, inherited property in which on birth somebody could have acquired a share.
Self-acquisition.
Then paragraph 2A, I have to go back one page, page 85.
Of the plaintiff that it is not under the Mitakshara law.
No, it is Mitakshara law applied because Daya Bhaga Mitakshara.
But whether the properties are all
All
ancestral,
no ancestral, it's all self-acquired.
that is why this partition is sought for.
It's Arun Bhutoria's self-acquired property. So on his death, his mother, his widow, and his 2 sons became heirs and are entitled to inherit his property. Had it been co-parcenary, I would have got a share, defendant number 1, not defendant number 2, defendant number 1. So made very sure, made very clear, it's all self-acquired property. It is so this passes on to his widow, that is defendant, that is the plaintiff. 35 mother, 36, 37 are the 2 sons. That's and it is made very clear at page 85, paragraph 2A. So it is a self-acquired property. Yes. At page 85, paragraph 2A, the father of late Arun Bhutoria was unable to work due to accidental burn injury. Late Arun Kumar Bhutoria had to start working at a very young age to earn the livelihood of the family. Comprising his parents and younger brother, the late Arun Bhutoria initially worked with his uncles Chhattar Singh Bhutoria and Nirmal Bhutoria as a property consultant on commission basis. And with the funds earned from such property consultancy, he started his own business of property. So it is all at that point of time that the defendant was a 16-year-old student. Looked after by Leela Arun Kumar. So it is his self-acquired property. Then paragraph 3 and 4. Next page. Argument enough, my friend? Argument enough? Should you put argument?
He's the main person.
Huh?
He's the protagonist and the antagonist.
So paragraphs 3, 4 are self-acquired. So I want to show from here, and then I will show, and on the other hand, the plaintiff is a Jamindar family. That's very good for her. Wish her all the best. Now, Lordship, kindly come to page 93.
You also come from
Page 93. Yeah. Okay.
Yes, page 93.
Hmm.
Now,
Now-
coming from a Jamindar family, I don't know why he's complaining.
My grandfather used to write, don't write Jamindar, write Jamadar. So that's how he would describe himself. Page 93.
Jamindar,
Jamadar. This is Harish Tandon. His father used to, so he knew my grandfather very well because his father and his grandfather used to, so he used to tell me that this is how he would tell his father, Mr. Gan Tandon. Huh?
That was a matter of pride.
No, I'm a Jamadar.
Right.
I don't know. I'm not a Jomidar, write Jamadar. Don't write Jomidar. I am a Jamadar. I have no Jomi to, I don't own any Jomi, so Jamadar you write. So, paragraph.
Jamindar means land. Jamadar means
And
British.
British. Okay, ঘোড়াটোরা করে না ঘোড়াটোরা জমাদার হয় ঘোড়াটোরা আছে page 93
Page 93.
paragraph 12a initially Arun Bhutoria had purchased properties in his own name, particularly the property purchased by Arun Bhutoria in his name were two flats and one residential, two residential. So A, B, and C. Now, Lordship, see, so these are his personal properties. That's his case. Whether they are still there, that's a different matter. I don't know. Later on, the late Arun Kumar Bhutoria acquired properties through various companies. So it becomes company property. So barring this, everything is company's properties. Later on, late Arun Kumar Bhutoria acquired properties through various companies floated by him. The shareholdings were under the control of Arun Bhutoria, either directly or through his nominee trustees. Gone. So admits that barring these four properties, these three, are those there in the schedule?
That is 12A.
12A.
A to the, this is there.
দেখো দেখো তুমি আমি মাপ করিয়ে দেওয়া আছে কত এটা
Item 10 of
10.
A2. Item 10 of A2.
These are the three A, B, and C.
This is 15.
And
10, 12, and 15.
these are the three properties which I have to go by demurrer, assuming they have to be as per pleading. This they can seek partition between plaintiff, defendant number 35 to 37. I do not mind if the suit remains with that. But-
Defendant is including your client.
Defendant number 35 to 37.
35 to 37.
No, that is their pleading because that is the case at page in the first where they said that he died 35 to 37 are the
1/4 share.
1/4 share.
40. That's 40.
No, there's paragraph 40 capital A. I just now placed my paragraph 40 capital A. That they are the heirs of yes, page 127. তোমার মিস হচ্ছে অনেক আমার হবে তুমি একটু সিদ্ধার্থ মিত্রকে বলো তুমি রিকোয়েস্ট করো Just see paragraph 40 capital A, page 127. Under facts that it shall be evidence, assets and properties, schedule A. After his death, third line of after his death, the said assets and property devolved upon the plaintiff and defendant number 35 to 37, having 1/4 share each. So they are the legal heirs of, and the praise are also that. Kindly see the praise. A between defend numbers, between plaintiff and defend numbers 35 to 36.
You're reading 127 40A.
40A. 40A is the third line.
Comes to late, yes, after plaintiffs and defendant number 35 to 37.
Three properties, that is paragraph 12 capital A I had placed.
So 35 to 37 are the years.
Yes. And the plaintiff herself also.
Plaintiff and the years.
Yes. Of Arun Kumar Bhutoria. This is self-acquired property.
Yes.
So আজকে মতো হয়ে গেলে বেঁচে যাই আজকে আমরা তোর মতো মামলা ধরবে না আমারও ধরেছে না আমার আছে আজকে আজকে
The order 7, rule 11, if you have to speak for so long, that means that application should be dismissed. Outright. He has to labor so hard to get the plaint dismissed, that his application should be dismissed.
Order 7 rule 11 is also not very easy thing. That
No, not very easy.
mechanically order will be passed.
No.
So my lord,
That is why he is taking so long. It's not very easy. That is why he is taking so long.
I am less competent than you, Mr. Mitra. That's something I always admit. So what you can do in 2 minutes, I cannot do. Never achieve that. It's my misfortune all my life.
No, it's a good fortune. Good fortune. It's a good fortune. You're born fortunate, you live fortunate,
That's it.
living fortunate.
And can you see the prayers?
Anyway, can you conclude today?
No, I will not conclude. I have to several
Next
judgments.
day, continue on the next day.
The Hoitra Basul Lekha.
CA 11 of 2025 not conclude its submissions. Let this matter hear on.
Next available date, Melrose.
Or fix a time.
10,
Time will
10.
Fix the time because there is some urgency on our part.
It is next Tuesday.
Yes.
Whenever Lordship says.
I can keep it on 14th also if you so desire.
Only
Okay,
14,
19
19.
2025 at 10:30 a.m.
Whenever Lordship says. I'm
Great.
grateful.
I'll make a copy. Learned friend is appearing. I cannot oppose him.
Yes.
He's a member of the Bar Library Club. Cannot oppose.
Right.
Junior member to you, Mr. Mitra, even more easy.
He has given additional reasons for not opposing. Very competent, very competent.
That is why patience hearing should be given.
Yes, that is why your lordship will hear him not once but 3 or 4 times on the same issue going over.
Right.
And next Tuesday, the Lordship is fixed it at 10:30.
ঠিক আছে?
Next Tuesday at 10:30.
Yes, 19th at 10:30.
Lordship.
Huge amount application.
But, since
Number 2.
Siddhartha, since Lordship has heard this matter, would you Lordship keep it as part heart matter?
On the next day,
On the next day, Lordship will decide. Very, very good.
yes, item 2.
Yes, I'm the degree holder.
In this matter, part payments, according to you, part payments were made pursuant to the issuance of the warrant.
Yes,
So, judgment debtor was also directed to be present today. Yes.
Government data did not appear before.
Yeah.
I will the department to directed to issue the notice to the judgment data.
Yes, Garnet advocate for the degree holder is present. Judgment debtor is not present in spite of order dated 22nd July 2025. The department is directed to issue notice upon the judgment debtor requiring his presence on 26/8/2025. 6th of September. Wait, 26th of August. The local person, judgment.
Local person, that is expression.
Okay.
I'm a
Yes, next.
My lord, in this matter, I am appearing on the petitioner. My lord.
Petitioner. Yes, GA application is your.
Yes, my lord. I am the administrator, joint administrator. My lord, executor filed probate application, my lord. Thereafter, my lord, sole executor died. The beneficiaries made an application for converting the same to a letter of administration. That application was allowed. And thereafter, my lord,
Your prayer is
yes, my lord.
no affidavit in support of the caveat is filed.
Yes, my lord. Every will support of the caveat is filed.
Filed.
Yes, my lord. And thereafter, my lord, they are not interested now.
Not represented.
Yes, my lord, I have served the copy.
Lordship, I'm appearing on behalf of the caveat, and
But yet not taking steps.
the matter has been settled outside the court, and we don't have any objection.
Do you don't have any instructions with
My lord,
regard to
I'm made an application. Finally, see the prayer of my master summons.
Yeah,
And they have already given consent, my by a letter, which I have annexed in paragraph.
Are you opposing this application?
No, we are not.
Record an order. Learned advocate for the petitioner. Administrator is present. Learned advocate for the opposite party caveator is also represented. Learned advocates upon hearing it is the contention of the learned advocate, learned advocate for the petitioner that the caveator has not taken any steps pursuant to filing affidavit in support of caveat, and this matter be appear under the heading non-contentious.
Yes,
Learned advocate representing the caveator does not oppose this application. In the facts and circumstances, this court is of the view that this application should be allowed. Let there be an order in terms of
prayer
master. Let there be an order in terms of prayer
A, B, and C.
A, B, C of the master summons dated 31st day of July 2025.
I'm
Application date of 2025 stands disposed.
grateful. Non-contact faculty. Grateful. Item number 4.
My lord, this is my application on behalf of Ramakrishna Mission. In a pending, interim application, in a pending probate application. Now, may I, my lord, kindly, may I briefly apprise yourself with your lordship with the facts of the case before I come to the prayers in application. Now, facts, I have admitted facts I have stated in the affidavit in reply. Kindly take up my affidavit in reply.
Your Lordship, this is exactly the why I on the last
No,
occasion. Your Lordship,
these are all admitted facts. So kindly, my lord,
whether it is admitted or not,
may I place it?
there are two people who have sought for probate of two different wills.
Mine is a second will, his is a first will.
Whether that is a second valid will or not, there are various
valid or not
applications.
is a separate thing. It's my application. My lord, let me place
Your
the
Lordship,
application.
the only no before Your Lordship, before he starts, that's why I indicated on the last occasion, he has used his affidavit in reply to now produce uncontroverted averments, which have nothing to do with his application, initial application.
We'll see. Let me place my application.
plead any new case or?
No new case, no
Entire
new case.
set of facts,
No,
Your
no,
Lordship.
no new case.
Let us consider it.
Yes,
on the merits.
your lordship will reject
But
it if your lordship.
Your Lordship, I haven't had a chance. That's why I indicated last time also. I haven't had a chance to file an affidavit on that.
Affidavit
For
reply to the
months.
reply.
Yes, absolutely. If you,
Unless he has taken any new.
Your Lordship.
No, I have
20
not taken a new
paragraphs of
pen.
facts
No, new
20
points he and my
20
learned
points.
friends taken in the affidavit in opposition.
That he can
Kindly
go to
place
court.
my
That he
face,
can
your
go to
lordship.
court.
If your lordship feels, your lordship will grant him an opportunity. May I, my lord, place my case? It's a second will. They are trying to delay the proceeding.
Yeah, how can I be
They are in control.
Your Lordship, I have asked for a handwriting expert to be appointed.
No, that prayer has been rejected. Kindly don't mislead the court.
There is no rejection. There is no such rejection. Handwriting expert rejection. What? Where? Where is that order? Please show me.
I have, my lord, filed my affidavit in reply. It is all the facts I've stated for your lordship convenience. Your lordship will has to
So he's going
go
to
through the
he's going
facts.
to
Yes.
plead his case on
Yes.
the basis of an affidavit in reply.
No, let
That-
me
that
do it in my
you-
way.
No, no, you
can't
cannot.
stop
No,
me.
no, that is what you are doing. You
No,
are
no,
you
please,
play-
please don't
you are
interrupt.
you are placing
You
your
place
don't-
your application,
you-
place
yes,
your
place
Kindly-
the application, not the affidavit. in
No,
reply.
I want to
He-
place the facts from the affidavit reply. Yes.
So his facts.
I'll
and
come to the application. I am
In
placing the
reply.
facts from the affidavit in reply.
His facts
Sorry.
and affidavit in reply,
No.
not in the application.
Better do one thing. come
Yes.
with The list of dates and.
Yes.
No, my lord, let
He
me
will come back.
Consider the.
Yes.
my lord, let me place the facts from the affidavit reply.
Yes, why will
some
some-
facts?
Sir, your lordship, there is a,
Very well. I'll
Comments from the affidavit in reply.
because I've
yes,
Comments from the.
no. Yes, I know.
Comments from the back.
No. I want to comment from the back in the petition interim. Very well. I'll just apprise your lordship
You
with the
come with
facts.
the list of dates and you written.
It
notes,
is
then
all
I can-
there, my lord. Let me place my case. Kindly come to my lord, paragraph 4. These are all admitted facts just to apprise your lordship.
paragraph 4 or what?
Paragraph 4 of the affidavit in reply.
Again, your lordship, he does not want to go to his own application.
Yeah,
He wants to
I'll
only
come to-
he only wants to go to.
my learned friend
He has also- He has also filed a supplementary affidavit. Thereafter, now he wants to place his facts only from the affidavit in reply. Where I have not been given.
let him
Yeah, because I have not been given a chance to control.
Yes.
My lord, the probate application, this is the interim application in which the instant application is filed, is a probate of the last will dated 8/1/2014. There are two wills, the later will in favor of Ramakrishna Mission. One, Ramendralal Addi was appointed the sole executor of the said will. He is a partner of Sanderson Morgans. The testator bequeathed all his assets, both movable and immovable, which he owned and possessed at the time. These are all admitted facts. Unless your lordship goes through the facts, your lordship will not understand what prayers I am making. Of his death in equal shares, absolutely and forever, to the following beneficiaries: the Ramakrishna Mission, Bharat Sevashram, and Dokhin Kolikata Sevashram. On 8/1/2014, the said Ramendralal Addi applied for probate of the last will of the testator, which is being contested by one Anjan Shil, my learned friend client. He is the nephew. He is contesting on the basis of an earlier will. That is why he is so
Your
agitated.
lordship, this is exactly the reason why
Agitated.
it's
The nephew of the
uncontroverted
testator.
what he is saying.
The said Anjan Shil has filed another probate application, is admitted, which is numbered PLA number 94/2014 for grant of probate of an alleged prior will of the testator dated 12/6/1999, which is not a registered will. It is pertinent to mention that during pendency of the said second application for probate, that is my application, the executor, namely Ramendralal Addi, had filed an interim application in the probate application in which an order of injunction dated 24/9/2014 had been passed and restraining the respondents opposite party, including Anjan Shil, from dealing with and alienating and disposing of the properties mentioned in the will. In this condition, crave leave to get a copy of the orders, etc. Now, paragraph 9. On 21/6/2019, during pendency of the said to probate application, the said Ramendra Laddi, the sole executor of the last will of the deceased testator, dated 8/1/2014, who had filed the probate application, with a letter intimated inter alia that the applicant herein that he wanted to relinquish his office as the executor of the will. So my executor, partner of Sanderson Morgans, had expressed his intention to relinquish. That's why I thereafter the said beneficiary of the will, etc. Then kindly come to paragraph 11. On or about 39/2019, the Ramakrishna Mission Institute of Culture, Gold Park, the applicant herein, filed an application being IAGA number 2 in the form of master summons for recording the renunciation of executorship of Ramendra Laddi under section 230 of the Succession Act. Subsequently, the Ramakrishna Mission also filed another application for.
You see, your affidavit in reply is not confined only to the opposition.
No, no,
I brought out so many facts.
no, kindly see.
Opportunities to be given.
These two applications have been allowed. Kindly see, these two applications are.
Very well, you see, so many things.
No, kindly see, these two applications, I'm coming to the nutshell.
Every time, every matter, this is exactly, this is what is done. Every application, they will, they reply.
Just bear with me for 5 minutes. Now,
Your
the
Lordship,
second,
just have to
these
get-
two applications.
This is their affidavit, their application,
See,
two
I have brought-
volumes,
yes, I have
then
brought-
supplementary affidavit. After that,
Matter
yes,
of merits, okay,
Just-
but see the process.
No, kindly bear with me for 5 minutes. Now, these two applications, one for renunciation of the executor recording of renunciation, and the other application is for conversion, amendment for conversion. Both these applications have been allowed by this honorable court. Kindly come to the order of Krishna Rao, Justice Krishna Rao.
What interim protection you
Now,
have?
two interim protections. After, it is very surprising, after the applications were allowed by Krishna Rao, we went to the department to carry out the amendment to convert the probate to letter of administration. Department said, surprisingly, after your lordship allows an application, can the department sit in appeal? Now, the department said, no. What you have to do, you kindly come to paragraph 40. Kindly come to my lord. Before that, kindly come to Justice Krishna Rao's order once, paragraph 43, page 43 of my affidavit in reply. Page 43, Krishna Rao's order. Both these applications are allowed.
master summons টা কোথায়? Master summons টা কোথায়?
May I place this order? Mrs. Nilanjan Addo is appearing for the executive. Jayati Chaudhary, learned counsel, is appearing for caveatrix. Mr. Devdatta Sen is appearing for the beneficiary. The beneficiary of the will, namely Swami Supurnanando, the secretary of Ramakrishna Mission, has filed the present application for renunciation of the executorship of Ramendra Laddi with respect of the last will and testament of Radhanath Sil. The applicant submits that the executor, namely Ramendra Laddi, by a letter informed the applicant that due to his personal difficulties and certain commitments, he is not in a position to continue the present probate, and on the basis of the communication, the applicant has filed the present application. The caveator have filed their affidavit, etc. Then after hearing, kindly go on to the next page. My learned friend saying that in their caveat, the caveat have denied the alleged will and executor by Radhanath Sil and submitted that the will relied by the executor is not a genuine will and is a forged document. Now, the court finds that with regard to the genuinity of the will, the same is to be decided during trial when the case for grant of probate will be taken up for hearing. In the present application, the application is only prayed for renunciation of the executorship, and this court finds that no purpose would be served for keeping the application pending. Accordingly, prayer is allowed. So renunciation recorded. Now the second application, kindly come to the next order. The applicant Swami Sharu Supurnananda, the secretary of Ramakrishna Mission Institute of Culture, has filed the present application for conversion of PLA from grant of probate for grant of letters of administration, and also prayed for amendment in the probate application, which is annexed with this application from page 9 to 19. The caveators have filed their affidavit. They had a hard-on contest. Affidavits to the application and submitted the alleged will on the basis of which the present application intends to convert the PLA application from grant of probate to grant of letter of administration. The alleged will has not been executed by the testator and the said will is a forged document. This court finds with regard to the genuinity of the document, which my learned friend was saying, the same cannot be decided in the present application, and the executor appointed by the testator in the said will has been renounced from the executorship of the said will, and the petitioner, the beneficiary of the said will, intends to continue with the said case, that is Ramakrishna Mission, for grant of letters of admission. Accordingly, the prayers A to C of the master summons are allowed. So the conversion A to Z was allowed, conversion from probate to letter of administration. Now what happened when we went to the department,
What is there?
disposed of, it is found from the record, the caveators, now their application. They had filed an application praying for an order for appointing a handwriting expert, which my learned friend just mentioned. And as this was denied, the court finds that the application filed by the caveator is to be taken up, is converted,
No denial.
up for hearing, is converted to a
that's-
letter of administration. Let the application being GA along with this be listed along with the main
Your Lordship,
application.
that is the
Now-
first thing.
Now,
Like,
now the
all
question,
along he has been saying it's
This application
Now,
for,
this
your
app-
application for.
now this application first prayer is for correction of, this is at the behest of the department. Department is not carrying out of the amendment as directed by Krishna Rao J because of, according to the
Let
department.
that be carried out. Thereafter, you move
Yes.
to other application, other prayers.
Very well, then let that be carried out. Let that,
Yes. The GF, learned advocate for the applicant.
Hmm.
You are for representing the
the beneficiary of the second will.
learned
Ramakrishna Mission.
for the representing the beneficiary of the will of the.
Your Lordship, there is a reason why this is not being done. I had
No, no,
indicated. No, please.
Let us
No,
let-
no, no, no.
Let
No,
me
let
tell
me
you
never-
why it is not being
Yes.
done.
No, let me
Yes.
tell Your Lordship. No, please.
You see, when an order is there, something has to be done.
No, Your Lordship, there is a reason. This matter has been there. Some other orders also in this. Who is the person who is going to represent? Whether that person actually has a proper authority or not? No,
Very
Your
well,
Lordship.
that
There,
can
there are orders on this. These which have not been indicated now.
Anyway,
This
that-
court has passed
so far
orders, Your
so
Lordship.
far that order is there, it has reached its finality.
Yes.
No, Your
Yes.
Lordship. No, Your
Yes.
Lordship. This order is of January 2024. And I think there are subsequent orders.
See the report. Okay, if the department thinks difficulty, a report will come.
Your Lordship,
Learned
may I?
advocate- Yes, learned advocate representing the beneficiary of the will of Radhanath Shil, moves the application GA5 of 2024. Learned advocate, you are representing whom?
The nephew of the testator,
Nephew of the
Testator.
Testator.
Yes.
beneficiary of an alleged earlier will.
the testator is also present. Our learned advocates, as the learned advocate for the applicant draws attention to the order dated
No,
January 8, 2024, past date GA 2019, I believe.
Yeah, no, the conversion is GA4, second GA4.
GA4 of 2023. And in GA, who is forward?
Two is their application for handwriting expert, GA4.
Of 2023, but the said order has not been implemented,
Yes.
for which the petitioner has come with this application. As the petitioner, along with this prayer, has made other prayers which cannot be considered at this stage before the order passed in GA4 of 2023 is carried out.
Your Lordship, may I just indicate their affidavit? Please, Your Lordship, just have a look.
What is the for
No,
what
no,
reason?
this is
please,
allowed,
please,
it is not
please,
preferred.
please, yes, Lord, 1 minute.
Yes.
Please.
I have not suppressed anything.
Very well, very well. What-
Your Lordship, a supplementary affidavit, Your Lordship, he has filed. If Your Lordship just looks at it, there's the person who they want to change the name.
I'll not consider nothing, no prayer I'm considering.
No, for the correction, Your Lordship, they are changing the name because once it becomes a contested hearing.
My lord, these let him submit. Very well, let him submit.
Suparnananda, this entire thing has not been considered, sir.
Suparnandanda's authority I have indicated here.
Yeah, where have you?
Why will I show? You have not
Where-
read the brief,
Your
then
Lordship,
don't
no,
argue.
that is exactly the reason.
They are trying to
Your Lord-
delay at any
Your
cost.
Lordship, they do not want me to.
That is an
No, 1 minute.
administrative-
Your Lordship, just wait.
They have not preferred any appeal from that order.
Need to. because your lordship, the thing is, I don't need to prefer an order from that order. His authority is the one which is in challenge, which we have taken up. That is why.
Can he take it? He has not taken, he has not assessed the order. That is concluded.
Your lordship, now what they are doing is, that is why I said I need to write something against the averments of the reply. They have produced authority in the reply, not in the application.
Let the department file a report, your lordship will consider. I'll make my submission.
Let the department file a.
As the order has not been carried out, the petitioner has come out with this application.
No, your lordship,
Before other prayers are considered, this order has to be implemented. Thus, GA 5 of 2024 stands disposed. Let there be an order in terms of prayer A of the master summons dated 5th December 2024.
Very well.
The other prayers cannot be considered at this stage.
It's kindly.
Liberty is kept open to renew the prayers at a subsequent stage.
By filing another application. Your lordship is disposing a comment.
No, please.
Wait.
No.
Let me complete. He will not make me. Let me submit.
Lordship, have a look at this. This is of 2024 after this application has been filed.
Yes.
These orders are not being shown. There are various orders in this.
I have annexed every order. Your lordship permits, I'll show every order.
And that is why
you cannot dictate. You are not listening to.
Your lordship, the problem is they are doing everything on the basis of an affidavit in reply, which has been supplied to me about 10 days back, and I have not been given a chance to controvert the allegations and averments there.
Yes, what do you say about 19th December order?
Kindly see the correction which department has suggested. Correction.
No.
Which order
19th December 2024.
Yes, 19 December 2004, Justice Sugato Majumdar has passed this order. Kindly see, liberty is given to the Learned Council to correct the copy of the. This is the correction suggested by the department. The other things are allowed by Justice Krishna Rao.
As order dated 19th December 2024.
That correction may be allowed, yes.
24,
yes, also.
Passed in GA 5 of 2024 is submitted before this court. Liberty is granted to the parties to take necessary steps in terms of the.
Both the orders, Krishna Rao and Sugato Majumdar.
Order dated 19th December 2024.
And
just a minute, in GA 5 of 2024 as well as in Ageta koto bollam? Order dated
19 December এর আগে my lord 5 December ছিল
order 8 January 2020
and order dated 8 January 2024 passed in GA
5 of 2024.
No, this is there Justice Majumdar's order.
That one also.
This is GA2 of
GA2
of 2020.
GA2 and GA4.
GA5. This is
your lordship. No, that order was passed in GA2 of 2023 as well as GA4 of 2023. Your lordship has been.
This is the order of Krishna. I have annexed a copy.
Learned Council for the nephew of the testator is also present. Hard learned advocate dropped as the learned advocate for the applicant order dated January 8, 2024. Part GA4 2023.
GA4 of 2020.
Yes.
And in GA4 2023, but the said order has not been implemented. For which the petitioner has come with this application stopped as the petitioner along with this prayer as other prayer please taken up, considered at this stage.
Which cannot be taken up for consideration at this stage.
At this stage, before the order passed in GA4 2023 is carried out. Carried out. come with this application, এটা কি এখানে কাটা হবে my lord? এখানে as the order has not carried out the
Has not been carried out.
has not been carried out, the petitioner has come with this application before other prayers are considered. Considered this order has been implemented.
Before the other prayers are done, this order has to be implemented. Has to be implemented.
তারপরে my lord, তারপরে other prayer ওটা কি থাকবে না?
Other prayers,
Other prayers are considered. তারপরে this order has
no,
been,
other prayers cannot be considered at this stage.
এটা একবার হয়েছে my lord.
My lord, may I make a prayer? My lord, kindly not dispose of the application
No,
after.
no, no, no.
Then
Yes.
when they liberty to file
Yes,
a fresh
yes, liberty
application.
will be-
Yes.
তারপরে my lord, দাস GA 5/2024 stand disposed there.
No, 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 no. Learned advocate also submits an order in GA 5 of 2024, dated 9 December 2024. 19 December 2024.
এই যে as order dated 19 December 2024 passed in GA 5/2024 on submitted before this court, liberty is granted to the parties to take necessary steps. তারপরে in terms of the order dated
No,
19
my lord, the parties, the department is to comply with both the orders. Department is to comply with both the orders.
order dated 19 December 2024 as 5/2024 is submitted before this court.
The department is directed to take steps both in department is directed to take steps both in terms of order dated 19 December 2024,
Read with the order.
passed in GA 5 of 2024, well as order dated January
Yes, I am obliged.
2024, passed in GA 4 of 2023. GA 5, sorry, this is what GA?
5,
GA 5 of 2000, this application?
Yes, this is
GA 5 of 2023 is disposed.
liberty to
But
file a
liberty is kept open with regard to the other reliefs.
other prayers. To file an application if necessary.
Only one thing to be included. The person they wanted to include from it.
No, I cannot go to.
No, please don't. No,
Legal
please
document,
don't.
I will at least make my submission.
You
My
will
learned
make-
friend will not.
I have indicated.
Yes, the order is passed. No,
Your Lordship, I'm not indicating anything on that. Please hear me. He doesn't want me to make this.
no, maybe we
The
make
real
whatever.
officer-
I am not shying out.
Beneficiary, that is the thing the department has to check. The beneficiary is Ramakrishna Mission, as per that. Ramakrishna Mission.
No, Ramakrishna Mission Institute of Culture. His friend is wrong. Kindly don't make it. I don't have submissions.
Now.
Beneficiary is Ramakrishna Mission Institute. I am not supposed to educate him, my lord.
I don't like to get educated, but.
Please don't complicate the.
Yes,
matter.
uh,
I have
Your
meditated-
Lordship,
yes.
see, what
I
is,
have meditated
your Lordship,
order.
that is what is happening.
No,
They are
I'm-
not allowing me to indicate. one
He is not
thing.
allowing me to
Why-
express my
If you
application.
want some direction, come with a separate
Your
application.
Lordship,
Yes.
Just
No,
One
no further
sentence.
clarification.
Mission Institute of Culture, the person is a secretary of the Mission, Ramakrishna Mission Institute of Culture. That is what his position is.
Yes.
But that is not a legal entity. That person, that.
We cannot consider this at.
Yes.
at
But
this
how
stage.
can that person be named?
Very well. Come with separate application.
Yeah,
If you
come
want
with
to challenge this,
Come
his
with the-
authenticity, come with a separate
Yes.
application.
Item number 5. Number 5.
Not today.
Item number 6.
I appear for the decree.
Number 6, I'm appearing for. Well, I'm appearing for the decree holder leading Mr. Singh, my lord. My lord, in this case, my lord, there's a requirement of 3 weeks extension for the commissioner to file his report. The commissioner has been tirelessly taking steps for the purpose of ascertaining the legal heirs of the judgment debtors. My lord, this matter, it was a suit wherein I had asked for repayment or return of the advance amount paid as suit money towards use and occupation of a premises. My lord, for in that, as in my suit, a chapter 13 application was filed and a decree was passed. There was a direction that that amount would be repaid. I am entitled to repayment because behind my back, the then landowners had rather it was put under SARFAESI proceedings, but they had taken money from me. Now, my lord, after the landowners were already dispossessed and I was also dispossessed from the property, my suit has been pending, and at that stage the one of the partners passed away. I had come up in the execution proceedings and sought for uh, taking steps for bringing on record his legal heirs. This partnership firm, my lord, their office, their existence could not be ascertained. At that stage, my lord had appointed a special officer to ascertain the exact position. The special officer has got for time on the last occasion to file his report. My lord, he needs 3 weeks more time, my lord.
Yes, learned advocate for the degree holder is present. As the learned special officer could not submit his report today, the time to submit the report stands extended till 9/9/2025. Let this matter appear on 9/9/2025.
Much obliged, my lord.
Yes, call the next.
Item number 7.
Lord, I appear for the judgment debtor who has taken out this application, my lord. If your lordship recollects,
Hearing is concluded. This
no, my lord, no, they had cited one judgment which I was supposed to distinguish, my lord. Justice Patanayak.
No,
Court,
this is that matter, my lord, where an application has been made for dismissal of the execution application.
there only, I think, hearing is almost
Yes,
concluded. Only one judgment.
Yes,
to be
yes, that my
distinguished.
learned
Yeah.
friend has relied on.
No, you have relied on.
No, the written notes has been filed on the last occasion. Supplementary written notes was filed on the last.
File the written.
I have
Yes.
filed, they have
Regarding
filed
the
two notes.
judgment, what do you say?
My lord, there is a stark
The
difference.
judge
Yes, my lord, we had handed over on the last occasion. I had relied upon that judgment.
is in your compilation.
Yes, my lord.
We put that in compilation stuff. Written notes.
Yes, yes.
Oh, which one?
Yes.
My lord, kindly takes up this judgment.
This page
Page number?
The last judgment I'll just indicate.
is Justice Patanayak.
Yes, my lord.
But it begins at 77, my lord.
Yes, page 77.
Now, my lord, two things are very important, my lord. First is, my lord, here an objection was taken as soon as the affidavit of assets was filed, even before the judgment letter was put on the dock for examination. My lord. And, my lord, kindly comes to paragraph 4, my lord, once. The decree holder, pursuant to the leave granted by this court, filed its affidavit contending that the statements made in the affidavit of assets by the judgment debtor are false and incorrect, and there is deliberate and willful suppression by the judgment debtor in order to defeat the satisfaction of the decree. Here, my lord, no, there is no such affidavit by my learned friend's client. The particulars, on the contrary, my lord, I am led by Mr. Dutt. On the contrary, my lord, the decree holder himself in the affidavit in support of the tabular statement has said all the assets are outside the jurisdiction of this honorable court. May I place that portion from the affidavit in support of the tabular statement, my lord? And your lordship will kindly comes to Lord will kindly comes to
Para 6, my lord. Page 6. Oh, sorry. I'm so sorry. My lord. Paragraph 16, my lord, which is at page 8 of my learned friend's affidavit. My lord. The decree holder has also received information that the judgment debtor has properties situated outside the jurisdiction of this honorable court, but the decree holder does not have any particulars thereof. Lord, without, he says that to his best of his knowledge, they are all outside the jurisdiction. Now, my lord, he was given an opportunity to examine the witness. My lord, my witness was on the judgment debtor was on dock, my lord, and my lord, categorical statements have been made that he has a property in Cuttack, he has bank account in Cuttack. The property is there is a tenant in that property. That tenant is also from Cuttack, my lord. So, my lord, here in this situation where my learned friend says that he has not completed the examination of the judgment debtor, my lord. All three things, my lord, I have said: property, debt owing to the judgment debtor, as well as the bank accounts, my lord, are all outside the jurisdiction. My lord, kindly allows Mr. Dutt to.
My lord, your lordship has section 39 subsection 4.
Just to distinguish Justice Patronite's judgment.
No, I'll tell your lordship.
To others, you have argued and submitted your written notes.
I am not on that matter. For the purpose of reaching Justice Patronite's order. Wow.
But it is applicable to this case.
Yes. What I'm trying to impress is this. Section 39 subsection 4 is not on an application by any of the parties. I will take a note that section 39 subsection 4 is for the court to decide on its own jurisdiction, whether I have jurisdiction to execute it or whether I'll send it to somebody. Now, insofar as the decision of jurisdiction is concerned, your lordship decides jurisdiction on the basis of the petition.
Yes.
The petition, my learned brother junior has placed it. In his petition itself, he says that I don't have any properties within jurisdiction. I only have a bank account which is also outside jurisdiction. Now, will you kindly think of a situation, I don't file any objection to that. So the court is left with a petition where it says that there is no properties within. It is not for me to come, my lord, and say to the court that look, he has admitted. The court examines the petition and finds that, well, there is nothing. Now, my lord, in the judgment, which my lord, my learned friend has relied upon and on which your lordship, my lord, wants me to করা আছে দেখো মার্ক করেছে মার্ক করাটা দাও না your lordship will find, as my junior points out, that here is a case where in section 4, in paragraph 4, the decree holder has disputed the affidavit of assets. Here also, the affidavit of assets was there. The affidavit of assets have been, the contents of the affidavit of asset has been decided to be directed to be false. Now, but that is not the
so far the decree holder is concerned.
He himself comes and
No, is the examination of the judgment debtor was completed or it was incomplete? Not complete.
Not completed.
Anyway.
The reason is, my lord, the logical reason, my lord, is at paragraph, there is no paragraph, page 12 of that judgment. 12 of that judgment. Or, my lord, the lordship starts from page 11. It starts with, be that as it may.
The continuation.
Paragraph
12.
Paragraph number?
Paragraph Below page, internal page 11, paragraph.
Internal page is not mentioned here in the compilation.
Oh, in the compilation, the page is not mentioned, but then page, paragraph 12.
Paragraph 12. Okay, yes, Mohit Bhargava.
Yes. Now, Miller Lordship turns over the page.
I believe my learned friend is referring to running page 87 of this written notes, my lord. 87, my lord, it comes to. Yes. Just above. Also. 87, my lord. From the top portion, my learned friend is.
It says, where starts, be that as it may.
My lord, third line from the top.
In the opinion of this court, the aforesaid observation, that is the observation of section 39, is not applicable in the facts of this case. So the court is of the opinion section 39 subsection 4 does not apply. Here, Millard, we are trying to address the court that whether section 39 subsection 4 applies to this case. So, Millard, if your lordships, Millard, try and understand what is the reasoning, the court is proceeding on the basis that I am of the opinion that section 39 will not apply in this case because nothing is within and nothing is outside or nothing is within. I am not yet sure. Subsequently, the execution and is similar. The execution filed by the decree holder is for realization of certain amount of money, and not for execution solely against the aforesaid property. At this juncture, it would be profitable to reproduce the relevant provisions of the Code of Civil Procedure, Order 2141. Pausing here for a moment, Miller. The learned judge, as I said, Miller, is going on the petition filed in this case to come to the conclusion that section 39 does not apply. If your lordship applies the same test to the petition which is before your lordship will find that it is an admitted fact and it is not in dispute that the property sought to be executed is pure. So, Miller, this is the distinguishing feature. That's why I started on the 39 that the court has to examine the petition to find out whether the court has jurisdiction or not. In this case, the learned judge proceeded on the basis that the petition before me is such that it does not warrant application of 39(4) at this stage. There
scope of 41.
Then 41 is given. On perusal of the aforesaid rule, it clearly manifests that a decree is for payment of money the decree holder may apply to the court or for an order that the judgment debtor may already be examined on a date owing to the judgment debtor. And therefore, Millard, he goes on to say what is the distinguishing feature in the petition which was before the court. Your lordship will see. This line, until and unless such question is answered in favor of the judgment debtor to the effect that the entire property is outside jurisdiction of the court, the question of transferring the decree may not even arise at this stage. So, therefore, Millard, the petition before the court, the judge says, the honorable judge says that I am aware of 39(4), but the petition before me warrants an investigation and I am not at that stage. The petition before your lordship does not warrant that. So, Millard, each case, Millard, is decided on the basis of the facts before the court. Millard, it is Millard, preposterous to argue that the learned judge, being shown the Supreme Court judgment, will say that no, I have jurisdiction. But the distinction is indicated in that order itself. He says, I have not reached that stage. And here is a petition where your lordship, Millard, has actually or in that stage at the instance of the petition. This is, Millard, my first argument so far as this judgment is concerned. Others, Millard, I have cited. Mohit Bhargava. Millard, kindly look at another argument which your lordship may take it, may not take it. Millard, law provides that a decree can be executed any time within 12 years. The limitation is 12 years. I can make umpteen number of applications for the purpose of getting the decree executed to the last day. The law gives me that right. Judgment at a decree holder that right. Now, if you lordship look at the sequence of order 21, it first provides that in order to recover movable property, the court has a right to attach. Then comes the question whether attachment of a property within or outside. And that's for that reason the court asks the judgment debtor that you first give your affidavit of assents. Here I have given my affidavit of assents. Before I give my affidavit of assents, the petitioner admits that I have property which is outside. Now, if he accepts that,
The decree holder.
if the decree holder accepts that and proceeds that there is property outside, then law requires him to go and have his decree executed in the place where the attachment is. This is not a question of any harassment, that I know the property is outside. A decree holder cannot come and say that, yes, the property is outside. I know the property is outside, but I still pursue with this court and try and examine. This examination will come once the decree stands unsatisfied upon selling of those properties. He cannot, say that I know properties are outside, I am executing the decree, I will not go there, but you, the court, exercise your power and go for examination will only arise when the properties are insufficient. So therefore, in my respectful submission, this stage, although here the year has started, the examination has started, the stage for examination has not yet arrived because the court doesn't know that by executing the decree in respect of the other properties, the decree will still remain unsatisfied or not. So therefore, these are the 2 points which I wanted to make, that so far as this judgment is concerned, in the facts of this case, the court has made it very clear that I am in a position where order 39, he doesn't say that it does not apply.
No, this judgment, it does not apply. It is observed.
Yes. What I'm saying is that the court doesn't say, the learned judge doesn't say that order section 39 rule 4 does not apply. And
In general.
Yes. He doesn't say so. It says
In that case, it did not
yes. Well, those would be.
My lord, may I just give 1 minute reply, my lord? My lord is at page 87. Kindly turns back to page 87. My lord, the distinction that the learned honorable judge was trying to make, my lord, would be, my lord, prevalent from the first top 5 lines, the execution filed. The 5th line from the top, my lord, at page 87. My lord will see the execution filed by the decree holder is for realization of certain amount of money and not for execution solely against the aforementioned property. This is the distinction that has been given. That this is not an execution with respect to one certain property which is outside. This is a decree for, this is an execution for, my lord, a decree passed for recovery of money. My lord, in my case also, it is not one specific property in respect of which I have filed the execution. My execution petition, my lord, is also for recovery of money. Now, my lord will kindly take paragraph 13. On perusal of the aforesaid rule, it clearly manifests that where there is a decree for payment of money, the decree holder may apply to the court for an order that the judgment debtor may be orally examined as to whether any or what debt are owing to the judgment debtor and whether the judgment debtor has any and what are the property or means of satisfying the decree. So not just property, what are the means of satisfying the decree, what are the properties for satisfying the decree, and whether the whether any debts are owed to the judgment debtor. The court may make an order for attendance and examination of the judgment debtor and for production of any books or documents. Therefore, the question of transferring the execution proceeding would arise only upon examination of the judgment debtor in court on the question as to whether he holds any property within the territorial jurisdiction of this court. Until and unless such question is answered in favor of the judgment debtor to the effect that the entire property of the judgment debtor is outside the territorial jurisdiction of the court, the question of transferring the decree may not even arise at this stage. So this is the stage, my lord. Once the examination is complete and it is found that there is nothing inside, that is the stage when the court will transfer the decree. My lord will see that it is more clarified in the next sentence. It is pertinent to note that the judgment debtor is yet to be examined in the present proceedings to ascertain as to whether he holds any property within the territorial jurisdiction of this court or whether the entire property of the judgment debtor is situated outside. So, my lord, here in this case, my lord, the examination of the judgment debtor didn't even begin. That is the stage that was referred to. Now, if my lord kindly takes the application once and sees the last order.
This is continuing, then I will also have to
No,
say.
no, my learned friend
Please
placed it.
reply.
My learned. No, I just
was called upon to
Only
just
to-
clarify as
yes,
to
and
which
he referred
judgment is
to
applicable.
and his
You just confine yourself
yes,
within this
my lord, may I
judgment.
just once say why I'm referring to an order passed in this execution that I can refer to, my lord, that is the order of 20th of March 2025, which is as page 33 of the application that has been filed by my learned friend. It states that, my lord, the decree holder paid for an accommodation. He has examined the learned counsel for the decree holder on the affidavit of assets as filed by him today in part. My learned friend has already admitted that, because there is no other way, my lord, that I have only been able to put a few questions. And in that last order, the judgment debtor has been directed to produce certain documents before the court, my lord. It is at this juncture that they filed an application for transfer. So, admittedly, my lord, the examination of the judgment debtor is not complete. If it is completed and thereafter, my lord, sees from the entire deposition of the judgment debtor, my lord, that there is no property outside, my lord may transfer. That is the stage when one can transfer, when there is no credible document or evidence to show that no property is within jurisdiction. And I'm only replying to another aspect that my learned friend has relied upon by placing paragraph 16 of my lord, the execution application, saying that I have stated there that there are no properties within the jurisdiction. My lord, today may I ask myself this question: who best knows what is the property owned by them? The person concerned. I cannot say what the other person owns or does not own. May I just indicate that what has not been pointed out?
We know nothing.
I may know nothing. I may know something.
Ask the judgment debtor to come.
Absolutely, my lord.
You have given that.
Yes.
Mentioned that.
Now, if my lord kindly takes my written notes of argument, only one paragraph I'll just show. Paragraph number 11 of my written notes. Written notes filed by the decree holder. My lord, I am not going to show documents, my lord, but in this particular paragraph, I have stated for your lordship to consider the decree holder, my lord, paragraph number 11 at page 3. That's the
paragraph 11.
Yes, my lord. Paragraph 11 at page 3, my lord.
Yes.
Kindly seize, my lord. At the outset, the decree holder states that there has been a typographical error in paragraph 16 of the execution case filed by the decree holder. Instead of outside, it would be inside. Such typographical error is regretted. The decree holder has already prepared and filed a supplementary affidavit before this honorable court. My lord, that supplementary affidavit is on record. In such supplementary affidavit, the decree holder has explained that the decree holder has received information that the judgment has some property situated within the jurisdiction of this court. Now, my lord, today, my lord, may I ask myself this question? On the basis of this typographical error, will my lord come to a finding that yes, there is no property within jurisdiction and send it outside? When
was the supplementary affidavit filed? After examination of the judgment debtor?
After,
yes, I must.
After I filed my application.
Yes, that is
when
that.
did
That
he
is
realize?
true.
He proceeded with his application, and when only I pointed out.
Three things. When was the examination of judgment debtor done?
20th.
My lord, it was done on 20th of March
2025.
20th March 2025. My lord will find the order at page 33.
20th March 2025.
My lord. 25 only, my lord. We had filed this
case.
Yes, my lord. 24, my lord.
তোরে অ্যাপ্লিকেশন সাপ্লিমেন্টারি কবে ফাইল করেছি আমি অ্যাপ্লিকেশন কবে ফাইল করেছি
9th April.
আর সাপ্লিমেন্টারি
কবে করেছে?
Examination of judgment debtor
20th of March 2025.
যাও 11th May.
8th March 2025.
Yes, ma'am.
Yes.
9th April I
First.
filed my application.
1st May they filed.
Application for dismissal of the execution.
Yes. On the ground that the petition itself shows that the property is outside.
The application,
1st May করেছে after supplement.
application says, my lord, is inherent lack of jurisdiction.
And on 11th May 2025.
1st May.
1st May 2025. After being served with the application, then he comes and says that no, it is a mistake. Prior to that,
May 2025 supplementary affidavit.
yes,
Yes, ma'am.
trying to say that that is wrong. Inside should be read, outside should be read as inside or whatever.
So, my lord, on 20
No,
For correction.
yes.
supplementary affidavit, my lord. Yes. mentioning that it is a typographical error.
But it's very clear now. What is the intention of my
My
lord?
lord, last submission, my lord, I was able to examine last on 20th of March. Today we are in August. In these 5 months, my lord, I would have been able to, my lord, examine the judgment letter, and everything would have been, my lord, clear whether they have any property or not. And as I have submitted, my lord, and relying on the judgment to show that stage has not yet arrived.
You see, save and accept Justice Patronak's judgment, okay?
My lord.
You don't have any case in your favor.
My lord.
Normal rule is the.
My lord, I bow down to the proposition that has been.
Second is Justice Patronak's judgment.
Yes, my lord.
If it can be applied to this case,
My
then
lord.
to some extent you are saved. Otherwise, you have to.
My lord, if after examination I'm unable to find any property, my lord, I will have to go. But I want to be sure before going that there is nothing with it. Because, my lord, decree holder does not want to run from pillar to post to recover the money, my lord.
See, when the law is clear, the court has.
My lord, the law is clear. It has been explained in the judgment. What is the stage, my lord?
And you see, the Honorable Apex Court said the observation of the judge should not be read as an interpretation of the statute.
Absolutely, my lord. Absolutely. My lord, why did I file execution in this court, my lord? Because this is the court that passed the decree. I could not have filed it anywhere else, my lord. This was not arbitration. But now that I have been able to, my lord, affidavit of assets in on record and the judgment letter was in the box, I should be given an opportunity to examine to my heart's content that there is no property within.
How many questions were there before the judgment?
My lord, I'll just indicate
28 or 29.
page number 20. My lord, 29 questions I have asked only on one day. And my lord, on that day, say orders were directed.
That I have nothing.
Four documents.
No application was made for appointment of any special officer to inquire as to whether
My lord,
It's harassment.
question is no inquiry was made regard to either by yes or by
There was no
appointment
prayer.
of any special officer to cause inquiry about any further judgment. Only you say that
my inquiry is limited to examination of the judgment letter. I am inquiring from the judgment letters too.
inquire and get from him in this way.
My lord will be surprised the way the judgment letters lie on affidavit suppressing the properties that they have.
Is not so
My
the
lord,
remedy was to cause an inquiry by appointment of some
my lord, my
officer.
inquiry, my lord, I am doing by asking the judge. My lord, as many as 4 documents. This inquiry was proceeding. My lord, sees page 34, as many as 4 documents were directed by this honorable court.
During the pendency of this application, did you come with any materials that the judgment debtor is having a property here? During pendency of the hearing of this?
No, my lord. No, my lord. My lord, the best inquiry would come from the judgment debtor himself. Once nobody will lie on oath before a judge, my lord.
If he does not have any property,
I'll have to go. I will have to go.
Yes.
I bow down. That is why, my lord, the stage comes in. At what stage should I go? That is what has been explaining Justice Pattonak.
learned advocates, learned counsels for the party concluded submissions on GA1 of 2025. As the hearing is concluded, let this matter appear for this on 3/9/2025.
Okay. Grateful to my lord.
আরেকটা বই আছে deeply obliged ma'am.
কত নম্বর judgment letter হবে আমি? My lord, I am appearing in this matter on behalf of my lord, the judgment letter number 1. My lord will recall, my lord, Mr. Shane was appearing for the decree holder, and my lord had passed an order on the last occasion on 17th of July, appointing my lord.
Is the date fixed for submitting the report?
Lordship, I appear
Yes,
for the
my lord.
petitioner, my lord, decree holder. My lord, we have also already intimated the learned receiver, my lord. He is present, my lord. My lord,
Please fix for submission of the report.
Lordship.
Lord, I have already intimated to all the authorities. But from UTI only some communication has come.
The report ready today?
No, I'm not praying for 10 days time, Lord, to file the report as all the communication has not come.
Yes, learned advocates for the parties are present. Today is fixed for report by the learned special officer appointed in this matter. Learned special officer is also present and prays for time to submit the report. Such prayer is allowed. Let the report be submitted on or before 26/8/2025. Let this matter appear on 26/8/2025.
I am grateful to my lord. None.
For judgment of for short passover, my lord.
Yes, I appear for the degree holder.
Yes, next case.
But 70 crores. But 70 crores is due and payable by Coal India. But kindly see the there have been umpteen defaults on the part of Coal India in filing the affidavit of assets. Umpteen number of defaults.
I just ready with my lord. I have it in
Repeated
opposition. We have.
There is no question of any affidavit in opposition. My lordship had directed to file the affidavit of assets. It's been 2.5 months that the affidavit of assets have not been filed. But today, my lordship will kindly direct let warrant of arrest be issued.
Frequent passover, my lord. Mr. Devnath Ghosh is arguing the matter. Whether this order is complied.
No, it has not been complied. And I can show your lordship previous occasions like nature order was passed.
Whether affidavit of asset is ready or not, I just want this. We have ready with the my lord affidavit in opposition with the direction is to file affidavit of assets. You have not challenged this order before the higher forum. No, we have filed an SLP, my lord. Where please show.
That is dismissed.
No, SLP
from the appeal.
No, my lord.
Not
This
the
is
execution.
mean profit decree. Mean profit decree was passed in our favor. Coal India went up in appeal before the division bench. The appeal was dismissed. They went before the Supreme Court. The Supreme Court dismissed the SLP.
No, pending.
No, SLP has been dismissed, I am told.
Division bench.
Oh, division bench. No, there is
Nothing.
My lord, we have lying with the another
lordship had
execution matter.
directed on umpteen number of occasions
We
that
have
Coal
70
India should
crore
file their affidavit of assets.
Whether you have filed your affidavit of assets, you just we have disclosed, my lord, our entire balance sheet.
Para 22. Kindly see paragraph.
We are entire balance sheet. I have yes, record an order. Learned advocate for the decree holder and learned advocate for the judgment debtor is present. Right of the directions to file affidavit of assets by today. The same is not filed and without any justification. My lord, kindly give me passover, my lord. Give me passover, my lord.
Let warrant of arrest be issued.
No, one more opportunity is granted. File the affidavit of assets on 14th August 2025. In the event the said affidavit of assets is not filed, necessary orders will pass.
My lordship will kindly provide that in case they do not, because this is the 4th or 5th default.
I'm making it clear, please. Either you come ready with the affidavit of assets or you bring some order of stay.
My lordship will kindly provide in my lord's order today that in case there is a default in complying today's order, warrant of arrest may be issued.
Necessary orders. That is necessary orders.
Give leave to because file. Kindly see my tablet
affidavit in opposition in course of the day or tomorrow. That there is no bar.
There is no direction to file
The
affidavit.
previous occasion,
my lordship sees the tabular statement 70 crores and odd is due. And
we have already the interim order is continuing.
Yes, the interim order is continuing, but let them file their affidavit of assets. I will not be able to examine the judgment data if the affidavit of assets are not filed.
Balance sheet of this CIS.
Since the month of May, they have been praying for time to file the affidavit of assets. We are mid-August. That affidavit of assets have not been filed.
Please, I am asking.
Oh,
my lord. Next. What is the order? You just see that order. My lord, I will.
The interim order that your lordship had passed on 8th of July 2024.
It was
extended
for 8 weeks.
For a period of 8 weeks. May that be extended?
Interim order granted earlier stands extended for a period of 6 weeks until further orders, whichever is earlier.
Great.
Oh, good.
নোটিশটা দিয়েছো? নোটিশ দিতে বলেছিল না আবার আছে তো আবার দিতে বলেছিল my lord, two things, my lord. Last occasion, my lord, when we were placing the execution application, in view of the, my lord, I wouldn't say complicated facts, but facts are a little elaborate. So your lordship was pleased to direct us to come back with a list of dates. My lord, this is the list of dates. And my lord, we've made one more service since it's an old execution proceeding. And my lord, one of the state departments of the government of Bihar is a party. So my lord, we've served them once again. And if your lordship takes the 7th page of the affidavit of service, your lordship will find that they have been duly served. Well, it is not new, my lord. Even in the previous rounds, they have conspicuously, my lord,
stayed away from the proceedings. My lord, yes, but kindly take page 7 of the affidavit of service. Your lordship will find. Lord, what was sent was the letter at page 5. My lord, kindly see the. It was specifically mentioned that the matter has been made returnable on the 12th of August at page 5. Order was enclosed along with the forwarding letter, which was sent to the department. My lord, our concern presently is the District Board of Rohtas. The second judgment letter. My lord, the long and short of the execution is that, my lord, there was a suit for specific performance which got transferred before this court, decreed on compromise. Now, my lord, this compromise decree is what we have been seeking for execution. We are seeking to execute the compromise decree. My lord, orders have been passed from time to time. My lord, one part of the decree which relates to the district board of Bhojpur, my lord, that has already been, part of it has already been executed. So far as the remaining part is concerned, my lord, that needs to be executed. My lord, in the previous round, my lord, your lordship will kindly take page 46 once. Your lordship takes page 646. Your lordship will find this is the decree, page 46, my lord. Page 46. Here your lordship kindly makes a note. The plaintiffs are the District Board of Bhojpur and the District Board of Rohtas. So this is the suit which got transferred to this honorable court. And my lord, kindly take the first defendant is the present petitioner who seeks execution of the decree. And my lord, the other party is the liquidator. The company was in liquidation. Now, my lord, the first recital will give your lordship a complete insight into the dispute, which was the subject matter of the suit. My lord, at page 47. Suit filed against the defendants for a declaration that the agreements entered into by and between such and such railway company and the district of such and such from time to time as mentioned in the plaint are in full force and are enforceable by the plaintiff against the defendants for a decree for specific performance of the agreement modified. My lord, this is effectively, this is what it was. Then, my lord, kindly take the terms of settlement which starts at page 50. Now, my lord, the portion of the decree which we seek execution presently, if my lord will kindly come to page 51. Now, before page 51, Lord, kindly take first the upper part, one of the first paragraph of page 51. It is recorded that the first installment of such and such, Lordship will pardon me, has already been paid by the defendant number 1, which was my clients, to the plaintiff in terms of the order dated 18th May, passed by such and such in CP number such and such, with other applications as mentioned therein, and the rest of the installment shall be paid by the defendant to the plaintiff
in the manner as indicated in the terms of settlement pursuant to the order of 18th May filed in the application. Then the first installment of such and such will be paid by the defendant to the plaintiff at the end of January 2006. Well, Lordship, I will show your Lordship the document that it has been paid. The second installment of such and such shall be paid by the defendant to the plaintiff by the end of March 2006. Paid. Then, my lord, the third installment of such and such, then the fourth installment, then, my lord, now the obligations of the plaintiffs. My lord, kindly come to page 52, clause 7. The voluntary liquidator, which is my client, shall be at liberty to sell the landed properties belonging to the company in liquidation, particular whereof are set out in the schedule annexed hereto, the landed properties mentioned in the schedule which are not recorded in the name of the defendant company in revisional survey shall be recorded in the name of the company, and the plaintiffs, well, this is where we want your Lordship's direction. And the plaintiffs will take all necessary steps and render all assistance and address letters for the said purpose to all concerned authorities, including the municipal and panchayat authorities, as well as collector or other registering authorities. So, well, they are the authority. Now, they have to do it. So, unless that is done, the entire exercise will become an exercise in futility. Then, my lord, kindly take para 8. The defendant number 3A, as voluntary liquidator of the defendant number 1, shall be at liberty to sell the landed properties mentioned in the schedule annexed hereto and marked with the letter in such manner and such persons as it think fit and proper, and shall not have any objection, and the plaintiff shall not have any objection. Now, my lord, only if para 7 exercise is undertaken can I do para 8. Now I am not being able to sell the properties. Then, my lord, the sale of the properties as mentioned in the agreement of sale such and such, defendant to the defendant number 4 to the respective purchaser mentioned. Then, my lord, effectively, my lord, we are, my lord, kindly come to once schedule B, kindly, which is your lordship will find at page 68. Which is a part of the settlement. But kindly take page 68. Towards the middle of page 68, your lordship will find there's a underlined portion, curved underlined portion saying district Rohtas. Well, these are the land which is of the district of Rohtas, in respect of which the land records was required to be changed in my name in terms of the terms of settlement, and thereafter I exercise the right to sell the properties. So this is the exercise which till date is pending. Well, 111 acres of land is there. Well, this is the situation.
The applications are to be made to change the record of right.
Yes, well, that has to be done in terms of clause 7 by them.
In accordance with the terms of settlement.
Correct, my lord. If I may, my lord, if I may just trouble your lordship once again with that clause 7 once, which is at the bottom of page 52. This was the one of the principal agreed terms on the basis of which the suit was settled. Para 7, clause 7 at page 52. My lord, honestly speaking, my lord, candidly, my lord, unless there is a specific direction, nobody will do anything. These are authorities. My lord, our lighting letters, our trying to persuade them, my lord, does not even make any. My lord, they don't even wake up. They don't even, my lord, pay attention to repeated letters or repeated communications from us or even from the advocates. It is only an order of court in respect of which they'll take steps, if at all. Then, my lord, the letters are there. Now, my lord, kindly take once that 16,32,000 that we paid in terms of the settlement, that your lordship will find.
Part amount is paid.
Yes,
Partly it is complied.
yes, I have paid. Now they have to, my lord, perform their part of the obligation under the terms. So then I will pay further and eventually the work can be done in terms of the agreed terms of settlement. You got your suit decreed. I agreed to your terms. Well, if your lordship will once, for your lordship satisfaction, if your lordship takes page 185, it should be part of second volume. Kindly see 185. This is the amount which we paid to Rothas. Now, my lord, this, then eventually they receive it. My lord, now, my lord, page 186, your lordship will find there's a refusal to pay to take the remaining. Page 186, 185 is the amount that we tendered. And they finally received it. Yes. Finally, they received this amount. My lord, at page 2. No, my lord, at page 298, your lordship will find there is an order which is a part of the third volume. My lord, in order to make them accept money, my lord, we had to run at least 7 years. Now, my lord, kindly take page 297 once.
298.
297, kindly take, my lord, then I'll take your lordship to 298. My lord, kindly see High Court of Judicature at Patna, writ petition filed by us. Kindly see counsel for the petitioner. My lord, kindly see the petitioner. Petitioner is the present also the present applicant before your lordship today. Counsel for the petitioner submit that the petitioner is ready to pay the check amount through a demand draft to the other side, and the other side is ready to accept the same. Then, my lord, kindly take the next page, 298. Then, my lord, kindly take pursuant to the last order, second paragraph, dated 20th April, learned counsel for the petitioner has handed over the demand draft of 1632 to the opposite party, and the same has been accepted by the learned counsel for the opposite party, number 2. In view of the same, this application is allowed. Impugned order passed by the Chief Judicial Magistrate Sasaram is hereby quashed in interest of justice. Now, my lord, kindly see the acknowledgement given by them at page 300. Rothas Jela Parishad gives me the. So, my lord, 23 after almost, my lord, I'm losing count, my lord, almost more than 8 years, my lord, I am being able to tender the money, because unless I tender the money, they'll say that there's no obligation on my part. So eventually I file a writ petition before the Patna High Court, get an order, get them accept the money, give them the acknowledgement. My lord, then I start writing to them from page 300. Acknowledgements at 300, from there I start writing.
English translations.
My lord, each page, each letter's English translation is there. My lord, effectively what I'm trying to tell them is that please execute and perform the compromise decree. This is what, yes, my lord, 309 onwards, if your lordship will see, these are the letters written by us. This is the situation, my lord. Now, my lord, the prayers that I seek in the tabular statement. Otherwise, my lord, unless there are directions of court, they'll do nothing. Tabular statement কোথায় গেল? এটাই তো first book. এটাই তো। My lord, kindly take the tabular statement once. My lord, we are going back to those Privy Council days when it says that my lord, the what is it? What does it say?
Statement?
Yes, my lord, kindly take the tabular statement. The agony of the decree holder starts once he gets the decree. My lord, I'm just sitting with the decree. My lord, kindly take the tabular statement. My lord, kindly take prayer B, prayer 2 in the tabular statement. District Rohtas, now such and such, injunction restraining from dealing with alienating, then district B, record the name. My lord, kindly consider prayer 2B. 2B. My lord, 2B is more important than 2A because they are the authorities. So, my lord, 2B is what will actually, my lord, restart the entire process. So, my lord, in order to, my lord, B and C are, my lord, are connected to each other, my lord. If there is the name of state of Bihar recorded in the record of rights, it has to be deleted and my name recorded. So, my lord, this exercise B and C has to be done together in terms of the compromise decree. So, if your lordship considers, yes, my lord.
As because it is government authority and
My
this
lord.
is not a writ court,
My lord.
you see, only a direction can be issued to place the compromise decree and for them to take necessary steps.
Correct.
Because under this jurisdiction, execution, that order cannot be passed.
Well,
Solicitor will be permitted or a special officer can be appointed to make necessary, submit the necessary papers.
Yes, yes.
Steps can be taken.
Correct. My lord, if today's state is a party in a civil proceeding before your lordship, and my lord, that state suffers a decree. So, my lord, hypothetically, say the state of West Bengal suffers a decree, say for 100 crores. Your lordship is executing the decree. The lordship has to attach the bank account of the state and realize the money.
That is one thing. You see, when government authorities are
Yes.
rectifying the record of rights on the basis of decree or order or whatever,
Correct.
they have to decide the thing.
No, my lord, what I'm respectfully submitting, my lord, what I was respectfully submitting, it was their suit. They compromised the suit.
The record of rights are maintained by the state.
By the same department of Rohtas. If your lordship will see district, they are the district. So it is like the state of West Bengal. State of West Bengal, another department, say the Block Land and Land Reform Office or the Land Department records all the recording of the land is there with the same department. So the party here is the district of Rohtas. So the land is in the district.
Suit was between this
District of Rohtas were the plaintiff.
plaintiffs.
They were the plaintiff. It was their suit.
Yes. And ultimately,
That suit was compromised. And they said that I will transfer this land in your name and you pay so much of money. And this matter went up to the Supreme Court. So they lost all the way to the Supreme Court. So when it eventually came back, they compromised. So after the compromise, it is your compromise in your suit you have agreed that the land will be transferred to me upon making payment. I have made the payment. So unless you transfer, the remaining part of the decree will remain inexecutable. So that's all that I was respectfully submitting. And my lord, what I was respectfully submitting, my lord, lordship kindly consider passing orders in terms of prayer 2A and B. B and C, I stand corrected, my lord, B and C. Otherwise, my lord, this decree will never see the light of the day. If they have to say anything, let them come and say it. They have chosen to, my lord, compromise the suit in this court. সুপ্রিম কোর্টে অর্ডারটা দেখা তো। চলে গেল।
Bihar usually was not a party. State of Bihar.
No, no.
Though you see, state of Bihar's name has to be deleted. You see, press C.
Yes.
Delete the name of state of Bihar
Hmm.
and others from the land records. It is the first. It is the
My lord, thus, yes, my lord, if your lord.
That is not a party. So there lies some problem in giving
Well,
a mandatory order.
Anyway, if your lordship will see, the authority is, if your lordship will see, the state of Bihar through the secretary government of Bihar, then joint secretary government of Bihar, my lord, these were all, if your lordship will see the compromise decree, চলে গেল। My lord, kindly say, take page 44. District board. Well, this is the decree. Kindly see district board. Bhojpur now Jila Parishad Bhojpur through its Deputy Development Commissioner office. Yes, at the Arayan district of in the state of Bihar. Then the district board Rohtas. I am in Rohtas. So these are nothing but the state authorities.
No. Autonomous body. But what is your prayer? You see in the tabular state.
Yes, my lord.
Direct the judgment dated number 2.
Correct, my lord.
To delete the name of state of Bihar.
Yes.
And others.
Yes.
The state of Bihar and others are to be deleted from the land. So state of Bihar was not a party in this execution case, in this main case.
Yes, yes.
That is the thing. And the other is that to record the name of the decree holder number 1 and 2.
Correct.
That is their yoke line.
Right.
Anyway, I am concluding the hearing. I will file a just short written notes of arguments.
Very well, my lord.
Yes, learned advocate for the decree.
My lord, this is only for this purpose, interim purpose. My lord, there are other orders which needs to be passed. So lordship will kindly keep the application pending. Yes, sir. Yes.
For the freeholder petitioner is present. Case 14 of 2025 is taken up for consideration. None appears for the judgment. This court is of the view that no fruitful purpose will be served by granting liberty to file affidavit in opposition. Thus, Mr. Bose concludes his submissions with regard to the interim order. Fix. (21) 8/2025 for orders. Written notes of arguments regard to the points of law and facts may be submitted on or before 18.
Very well.
18/8/2025.
Very well. But instead of 21st, could it be 20th, subject to your lordship's convenience? 20.
I will be submitting on 18th.
18.
So let it be on 26th. 26th.
Very well, 26th.
26 8 করে দিন।
Very well, 26th. Grateful.
Bring your written notes.
I will.
of law and the facts.
Yes.
Lists of dates probably have submitted. Or
Yes, I have.
So that the question of interim order and
my lord.
Passed.
Item number 11.
My lord, in this matter, I am appearing for the judgment debtors. I have filed an application for dismissal of the execution kit, which is returnable, my lord, day after tomorrow, on 14th of August.
I am for the degree holder, my lord.
My lord, this is an execution case before my lord. I have filed an application.
That is GA1. GA1.
GA1, my lord, is the application for dismissal, which is returnable day after tomorrow, my lord.
Let this matter appear on 14/8/2025.
My lord, instead of putting a keep on 21st.
Let this matter appear on 21/8/2025.
I'm extremely grateful to my lord.
And there is also the returnable date. That application in the that is returnable date.
It is returnable because we had filed the master summons. It will come up on 14th itself. That time, if my learned friend wants, I'll concede to an adjournment.
Yes, and then that application also.
Grateful to my
I am adjourned.
Item number 12. Malad, I appear for the judgment data in this matter, Your Lordship. 12, 14 and 21, Your Lordship.
Yes. But I appear for the decree holder.
My application has been filed by my learned friend seeking attachment. My lord, we have completed our affidavits.
So affidavits have been exchanged. Now, my lord, I had given certain details of the bank accounts which the judgment debtor holds in various banks, which your lordship will find at paragraph 6 of GA 5, page 4. GA5 is my application for attachment of the bank accounts and disbursal of the money which are lying in the bank account in satisfaction of the decree. Now, lordship will find in paragraph 6 of my application at page 4, we had found out that these are the bank accounts that the judgment debtor holds in these banks. Now, in the opposition, they have not disputed that they hold these bank accounts, but they have also not disclosed what are the balance which are lying in these bank accounts. Now, admittedly,
29,000 is already paid.
10,29,000 paid.
It's due and payable.
Now the decretal dues as per the interest calculation comes to near about 90 lakhs. 88 to 90 lakhs. The principal decretal amount was around 26 lakhs, and as per the decretal rate of interest, we have given the calculation sheet as well. So lordship will find at page 33. Annexure B, page 33. Well, this is my calculation. What you will see calculation sheet in at the top table. Interest at the rate 18% from due date 3rd March 2014 to decretal the date of the decree 7th January, and thereafter 12% from the date of the decree till date. Now, that is the calculation I have given. The judgment debtor in its affidavit has evasively denied, has only said the calculation is not correct. But the judgment debtor has also not said what is the correct calculation. It also can't be disputed that the decree provides for a rate of interest on the decretal dues. Now, today, my submission is the judgment debtor has not provided any calculation. Even if I ignore this calculation, then also there are some amounts which are due and payable. Even the principal decretal dues has not been satisfied, admittedly. Even their stance is they have only paid 10 to 12 lakhs. Well, my submission is that the judgment debtor says that he has no money, but he has also not given particulars of the savings or the balance lying in these bank accounts. Lordship will, now it is absolutely unnecessary to direct the judgment debtor to furnish the balance amount. He will never do that. Lordship will kindly pass directions on these banks and the branches who will then certify that what are the balance lying in the bank accounts. If that can satisfy my decree, I have nothing else to say.
May I submit, Your Lordship? Many things have been said, Your Lordship. Malad will kindly take page 16 of their application. What is the principal amount due? Well, it's an order dated 7th January 2016. Malad has found it.
Yes.
Malad will kindly take 5-6 lines from the bottom. 17,18,961.44.
Yes.
This is the principal amount.
Yes.
Outstanding amount of a sum of rupees such and such.
Yes.
Now, Malad will kindly take my opposition ones. My submission to this honorable court is that I have paid the entire amount. I have paid the entire amount, even I have paid more. I have paid, Malad, as per reciprocal obligation, the decree holder has taken goods from me. I have annexed the records. And even I have annexed the VAT returns. There is no denial.
How much you have paid?
Malad, 17,35,307.
Such rate of interest?
Malad, may I submit, Your Lordship? 17,35,000, the goods which I have sold to him, plus
You see, executing court cannot go
Malad
beyond the decree.
will kindly hears me out. Hears me out.
Yes. No,
17.
you confine yourself within the decree, how much you have complied.
Malad,
Don't go beyond that.
Malad, I've given them 10,29,000.
Very well. What is the decree? What is the decretal amount? Just what is the decretal amount?
Decretal amount is
At the next page, will see.
it's 26,54,355.
6,54,355.
I have given them 10,29,000.
Very
Malad,
well. So you have not paid the entire thing.
this is the second application for attachment of bank accounts. Previously, an application was filed, bank account was detached, defreezed.
Yes.
I have paid 6,12,000 thereafter.
Okay,
Plus,
let us go by the decree. How much is the decree? How much you have paid?
Malad,
Thereafter proceed. So far, the decree is considered is 26,54,355.
Yes, Your Lordship.
Okay.
I have paid 10,29,000, whereas the outstanding amount, the principal amount was 17,18,000.
Don't go. What was the principal amount? Let us see what is the decree. How far you have satisfied the decree.
Well, I have paid 10,29,000.
That means how much is paid? 16 lakh.
16 lakh principal amount.
16 lakh principal
amount.
So that 16 lakh is not yet paid.
No.
What the principal amount is?
Yes,
concerned.
not yet paid.
Yes.
Well, I've made out a case, Your Lordship, where in the decretal amount has been satisfied. I have paid the entire amount.
Very well, I shall hear you. How far you have paid it?
Yes, Your Lordship will kindly.
The question is, you see, how can you pay it? You see, 26,54,000 is the amount. According to you, you have paid 12 lakhs. So how is the amount satisfied?
No, my lord. The principal amount, which was the then outstanding,
yes,
17,18,000 was outstanding as on the day. Malad will kindly hears me out for 1 minute.
Executing court cannot go beyond the decree. You see, what is the decree? How far you have satisfied? If you have not done,
Malad, the value of the goods has to be considered.
No, nothing. This executing court cannot go into that. Yes, record an order. Learned advocate for the decree holder.
Malad, the appeal is pending, Your Lordship.
For the judgment dated at present, submitted by the learned advocate for the decree holder, that out of that the judgment data till today has paid rupees 10 lakh
29,000.
10 lakh 29,000. Although the amount due and payable with regard to the principal sum excluding interest was rupees 26,54,355. Learned advocate also submits that the bank accounts of the judgment debtor be attached in the the bank authorities be directed to fund the amounts right. In the facts and circumstances, this court is of the view that a special officer be appointed to inquire as to the sums lying the bank account of the judgment debtor. Thus, appointed as a special officer to cause an inquiry as to the amount lying in the bank account of the judgment debtor, namely MS Shruti Exports. The following bank accounts should be inquired. Number one, এই তিনটে করে দেবেন এটা 1 2 এগুলো ঠিক আছে upon completion of the inquiry the special officer shall
Malad, a receiver has already been appointed.
Is already there.
is appointed with
But in respect of
Malad,
GA1.
in respect of
With
GA1.
respect to keeping the shares, share certificates of the judgment debtor in a separate company which he holds.
okay
So
there
that
will be
the special officer or the receiver can be direct.
joint special officer. What is your name? Chakraborty and Dash are appointed as joint special officers only for this purpose. The report to be submitted by the special officers is with regard to the inquiry. A learned special officer shall conduct the inquiry upon notice to the learned advocates for the parties. The report be submitted on or before 28/8/2025. Let this matter appear on 28 8/2025.
And with an advance copy of the report, then we can come and make submissions.
Advance copy of the report should also be circulated.
But Lordship was appointed joint special officer. But Lordship may appoint any other.
Along with her, I am just appointing
Man,
another.
very good. But one more aspect insofar as GA1 is concerned, but GA1 Lordship had appointed a valuer to evaluate ascertain the value of the shares that the judgment debtor holds in a separate company. Here, Malad, we have been communicated with certain letters which the valuer had intimated the judgment debtor to cooperate, and the judgment debtor has not cooperated at all. But that will be there from
upon instructions from the person himself. My lord, my client has already.
They are taking up only this application.
But all the three applications are there. Item 12, item 14, and item 21. Lordship will simply pass a direction upon the judgment debtor to cooperate with the valuer. That's all.
The judgment debtor is always cooperating. He has mailed.
I shall consider.
But we have the letters of the valuer. Valuer says that he's not cooperating. One line, if a Lordship directs, then the exercise can be completed.
Number?
J1 or item number
12, 14, and 21.
No, just now I have taken up item 12.
Item 12.
Okay.
This is
So item
J5.
14.
Item 12.
Lordship, heard of.
GA1, Lordship has passed an order appointing valuer.
Okay, that is already there.
That is already there. Lordship may pass a direction upon the judgment debtor to cooperate.
So this one I have item 14.
Yes, yes.
Item 14. GA12 এর order টা করুন। Learned advocates for the parties are present as it is submitted that the judgment debtor is not cooperating with the valuer. Learned advocate for the judgment debtor is requested to take necessary instructions in this regard and do the needful.
Well, he's cooperating. He has mailed.
I just told you to take necessary instructions. আচ্ছা item আরেকটা করতে আছে item
21.
Item 21 করে দিন let this matter appear on 28 28 না করে ওটাকে জাস্ট দিয়ে করে দিন okay 9/9/2025 তিনটে ম্যাটারই 9/9/2025
ঠিক আছে 9/9 কেমন
9/9/2025
instead of 28th August, Lordship is keeping in
9/9/2025 some time is required.
Yes, grateful.
Item number 15, minute by Leonard friend is here. But possibly needs instruction from his client.
Yes, that matter where award had to be sent for impounding, he'll come back to your lord.
Not this week.
Well, kindly pass a one-line order, Millard, so that
Yes.
we can also show our face.
Item 15 লিখে দিত
For necessary instructions, lordship can keep it.
advocate for the degree holder placed necessary instructions. This matter appear on 26/8.
Yes, that would be Millard. Sufficient time for us to come with
May I have
deep
a line leave Millard to mention Millard?
The examination for judgment at 12:30.
After recess.
Item 13, Milord, was fixed for filing of notes today. I'm just praying for 2 weeks' time. Just keep it after 2 weeks. My other side is here.
Come on Thursday, come on.
Lordship, examination of witness fixed matter 2 p.m.
Yes,
Lordship,
yes,
item number
2 p.m.,
43.
Yes.
Lordship, the plaintiff due to some difficulties.
Okay, mention that 2 p.m.
21.
Matter, this was due to appear today. Unfortunately,
Millard, kindly 21, Millard, item 20. Very sorry, Millard, item 21, Millard, for the decree holder, Millard, Rajiv Lochan, 22. I'm not there. That is the reason why.
Not item 21, not this week.
22. 22. Lordship will kindly, Millard.
21 or 22?
Millard, Rajiv Lochan, decree holder is Rajiv Lochan. That is Millard 22.
Item 22.
Millard, kindly record a one-line order, Millard. That would be very helpful for us.
Just making it not this week.
Kindly record.
Okay, on the prayer of the learned advocate, the matter stands adjourned till
After 19th,
So,
I will inform, Mr. I will inform. I am for the award decree holder.
on the prayer of the learned advocate, the matter stands adjourned till 21/8/2000.
I will inform, definitely.
I'm there for
Oh, very, my learned.
Give your to item number 18 and 19. There we are appearing for the defendant number 1 and 1. Can you see on the next
It will be taken up on Thursday.
Thursday? We have some difficulty.
Achha, 18 and 19.
I will inform the other side.
18 and 19, not this week. করে দিন।
I will inform the other side, my lord.
18, 19,
Not this week.
The plaintiff's witness's cross-examination is going on. My lord, for some difficulty, the plaintiff's witness is unable, my lord, to come before your lordship for deposing his witness today. May this be kept on any other day.
Yes, item
Lord-
43, record an order.
Lordship, there's a further submission, my lord. Lordship kindly sees the order dated 28 July 2025. Lordship remembers there was a mistake in the question numbers that were there in the deposition sheets, and your lordship had given a direction for correction of that. Now what has happened is, your lordship's order records the question numbers in this, my lord, the corrected question number is perhaps incorrect. It will be up to question number 194 instead of 195. For this reason, they are not being able to carry out.
Learned advocates for the parties are present. On the prayer of the learned advocate for the plaintiff, that the plaintiff's witness could not be present due to some difficulties, the matter stands adjourned till one
8th of September. my lord.
21.
Wait, lordship, 2 weeks, because this correction needs to be carried out. Otherwise, there will be the same difficulty.
Okay. 2/9/2025 at 2 p.m.
Grateful.
In order dated 28 July 2025, in paragraph number 5, it is stated from serial number 152 to 195. Instead of 195, it should be 194. Let necessary correction be made.
Lordship,
Other
kindly
contents of the order
direct the
dated
department to take it out.
other contents of the order dated 28 July 2025 remain unaltered.
My lord, may I be,
Yes, good.
my lord, may I be permitted to mention, my lord, for correction, my lord, perhaps, my lord, order dated 8 August 2020.
Let it appear as to be mentioned.
For judgment, item number 1, Meraj Rashid.
I'm happy for the plaintiff. This is an independent suit.
Yes. Hence, the plaintiff does get a decree for eviction against the defendant, her main agents and assigns from the suit flat as described in Schedule A to the plaintiff. The defendant is ordered to hand over peaceful and vacant possession within 30 days from the date of this order. As the defendant all along did not appear in the suit, and at the time of the inspection of the suit property, the door of the flat was found to be padlocked, for which inventory could not be made, it would be reasonable to appoint a special officer to affix this order on the outer door of the suit property at a conspicuous place for perusal and compliance by the defendant. Apart from affixing this order at the outer door of the suit flat, learned special officer shall also communicate copy of this order to the defendant at the place where she carries on business and place where she also resides, as reflected in the cause title. And thereafter, the special officer shall, upon communication of this order, affix this notice, and on completion of the intimation to the defendant, report shall be submitted on or before 29/8/2025. Fix this matter on 29/8/2025 for report of the special officers. In the event the defendant does not vacate the suit premises within 30 days, the plaintiff will be entitled to apply for execution of the decree.
I mean, well, special officer has already been appointed.
Yes, yes.
As well.
Joint special officer.
I'm grateful that.
এটা চলে যাবে, ওটা রেডি হয়ে তারপর তুমি মেনশন গুলো হয়ে যাক, তারপর 12:30 সাক্ষী।
To be mentioned, item number 24, John M. Malik.
Why don't
This matter has appeared in the list at my instance. One substitution application was disposed of on 25th
Yes,
July.
what is there to be corrected?
My lord, the paragraph B of the master summons I am praying leave for correction. Instead of annexer D, it will appear annexer B.
Yes.
And I am praying also extension of time, my lord.
Give me the order dated, last order. Where is the last order?
I am placing before your lordship.
This matter is put up for necessary rectification of order dated 25th July 2025. Learned advocate representing the daughter of defendant number 5 is present. It is submitted by the learned advocate that there is a mistake in the master summons dated 25/4/2024, and he prays for necessary rectification in prayer. Which prayer?
Prayer is paragraph B of the master summons.
Paragraph B of the master summons. In paragraph B, instead of
Annexer D, it will come annexer B.
okay, instead of annexure D,
It will come annexer
marked
B.
as annexure E.
B.
Okay, instead of annexure D, it would be marked as annexure B.
B will come.
B. Let necessary rectification be made. Petitioner is also granted liberty to cause necessary correction. Other contents of order dated 25th July 2025 remain unaltered.
Item number 25, person paid and others. Item number 25.
Not today.
Item number 26.
Your lordship, with item number
Yes.
26, on the last occasion, there was a direction by your lordship, the register, to file a report as to the change of number of 102A into a new number. Earlier reports were filed, but again your lordship directed the register to convert it into a new number.
Let me see.
In item 25, your lordship, I am for the plaintiff.
Okay, 25 I made it, not today.
Okay, your lordship.
PLA 227. এটা দেখি এখানে কিছু দিয়েছে রিপোর্টে লিখেছে। His details are having number as of this one. তাহলে নতুন নাম্বার অ্যালট করে দিয়েছে with regard to so 100 instead of 102 a new number has come.
What
that
is
is
this
PLA 227 of 1993.
PLA 227 of 1993.
এটা by order dated কিছু দেওয়া আছে corrected.
Lordship, then in that case, kindly direct the department to issue the certified copy of this PLA 227 of 1993, because earlier there was an order, but that was of PLA 102. By order of 13 May, your lordship directed to supply the certified copy. Order date 13 May.
তো দেওয়া আছে এখানে রিপোর্ট দিয়েছে in terms of order dated 23/7 ও 23/7 অর্ডার কোথায়? So the report was this 102 of 1993 in the name of Ichraz Devi Chajjar
That has been disposed of.
was never registered in
Never
the earlier lobby system. But so far the other
everything was going on manually.
yes.
Because in the year 93, I suppose that then at that point of time, A, something like that number was been allotted. And this is the same case. কি হলো বলুন না, এই তো কত 23/7, এই তো 23/7, পুরো অর্ডারের বাঞ্চটাই আছে।
July. New number 128.
সার্টিফিকেট কপির জন্য আগে অর্ডার আছে, বাট এখন নতুন নাম্বার হয়ে গেছে না, এখন নতুন অর্ডার
102 এর ক্ষেত্রে না এই 102 যেটা এক্সিস্টিং কার জায়গায় 102 হয়েছে ওইটার উপর মেরে ওই যে রেকর্ডটা কোথায় গেল কার উপর মেরেছে এটা 10 কার উপরে দেওয়া আছে আচ্ছা 102A হয়ে গেছে আচ্ছা 102A কে দেওয়া হচ্ছে যে 227 yes record and order learned advocate for the plaintiff is present
for one of the trustee.
Plaintiff one of the trustee
One of the trustee.
learned advocate for one of the trustee is present in terms of the order dated 23rd July 2025. The register original site has submitted a report. It is stated that PLA 102 of 1993 already exists in CIS within bracket corresponding to PLA 102 capital A of 1993. Thus, another entry with the same case number could not be created. Stop. Hereafter, new case number 227 of 1993 is allotted and registered in place and state of PLA 102 capital A of 1993. Certified copy be issued to the applicant with regard to the new case number with regard to the petition having the new case number.
Being
being
If it-
PLA 227 of 1990.
93 old number also your lordship would clarify then.
No, it is there. Acha, within bracket করে দিন
Old
190 102 capital A of 1993.
Deeply applied. Certified copy of all the documents.
Anyway, I made it petition. Thereafter, you can take other documents also.
If your lordship make it again, your lordship have to come before your lordship. If
Yes.
they don't keep up all the
Certified
documents.
copy of the petition and other orders.
Okay.
Liberty to mention.
Liberty to mention. Order is done. Deeply applied.
Item number 27, RMB distributors.
May it please, my lord. I pray represent the plaintiff in this matter.
Yes, you are appearing for?
The plaintiffs.
Yes. What is the stage of the suit?
The stage of the suit, I believe, my lord, was, I think there was just one IAGA pending. This is a changed brief. The matter was filed in the year 2004 by way of an order of a company petition, number 17th of 2004. My lord, Justice Banerjee was pleased to direct that there were certain documents which is subject to trial and which is why that cannot be entertained, the dispute cannot be entertained before the company court and a suit be initiated.
This suit.
Yes. Now, the issue is from 2004, the last order, as I could recollect, is in the year 2008 from the CIS system. Now, in the meantime, a lot of water has passed. Now, it has to be renumbered. This is a commercial suit, which is within the ordinary original civil jurisdiction of this court.
This is a commercial suit. So it can be transferred.
It has to be. It was a commercial suit filed in the ordinary original civil jurisdiction.
Commercial division.
Commercial division, and it has to be numbered as well. So, your lordship be pleased to pass a direction to take the necessary corrections that are required in the suit and let the suit be listed because the orders are also not available in
Take
the
necessary
CIS.
instructions, cause the necessary inspection. Thereafter, you mention.
I have inspected the file by way of a letter to the registrar of original site. All I can find is the IAGs were present and the original suit. There were no order copy in the file itself.
No,
So I have to upload.
whether issues are framed or not.
No, I doubt issues are framed because that was not in the file. And in fact, I'm not even sure whether this is the complete file which is presented before my lord.
So let it appear after 6 weeks. You take necessary instructions. What is to be done?
It has to be pursued. The instruction is cleared, but now all it awaits is my lord's direction.
No, if it is a commercial suit, it has to be released from this bench.
Yes, with proper, no, but I would rather request, or pray, my lord, that merely releasing, because this was of 2004, the ideal jurisdiction lie with my lord. If this is to be converted into a commercial matter and to be tried by the commercial division, I have no reservations to that, my lord. But there has to be a proper direction to the department as well as upon us to carry out, serve notice, come and let it be listed properly before.
First of all, you satisfy whether it is a commercial suit or not. If
It is a commercial. I will satisfy on that. My lord, be pleased to take the plaint for a moment. No. Now, I'll start from the memo of the parties. It is between a proprietorship and a limited company. And the dispute is arising out of goods supplied during the year 2000 to 2003.
Yes, record an order. Learned advocate for the plaintiff is present. Upon perusal of the plaintiff, it appears that the suit involves adjudication of a commercial dispute. Thus, this is a commercial suit. let this suit be released from this bench and be placed before the bench having determination to deal with commercial suits. The department is directed to take necessary steps so that necessary number can be allotted with regard to this suit.
Liberty be granted for certified copies of the order. I don't have a copy of the orders and it is not even available in the CIS, which is why I was praying before my Lord that an appropriate order so that I can
Yes,
get the documents.
plaintiff may apply for the certified copy of this order.
Not this order, the other, the previous orders, my lords.
You take necessary directions
Takes from,
the, okay,
as my lord.
from the bench.
Much obliged.
Item number 20, Manish Agarwal and others.
Yes, not today. Oh, item 28 at fixed at
Hamida Zakir and others.
The 29 appearing for the plaintiff. Last occasion, the submission of all the parties has been completed. You have kept it for
GA8.
GA8, my lord, for filing written notes of argument.
Yes.
Your Lordship, I'm appearing on behalf of respondent number 6, 7, and 8.
Today is fixed for filing written notes.
Yes, Your Lordship.
It isn't concluded by all the parties.
Yes.
Suppose have submitted.
So you have filed your written notes.
I will do that. No.
You are for the plaintiff petitioner. You are
For respondent number 6, 7, and 8.
Your Lordship, I'm for respondent number 1 and 2.
so today was fixed for filing only the written notes.
Yes.
Yes,
So you
Your
come
Lordship.
ready. You are ready today.
I can file my.
Your Lordship,
Or if
I'm
they
just
all-
praying for time for extension, whether I could file it on Monday, because we are unable to file it today.
Yes, record an order. Learned advocate for the
Fight my
plaintiff. Learned advocate for the parties are present. Plaintiff is ready with the written notes of arguments.
Even the defendant number 2 is ready.
Let the learned advocate for the plaintiff and learned advocate for the defendant number 2 is ready with the written notes of arguments. Let it be kept with the record. Liberty is granted to the learned advocate for defendant number
6, 7, and 8.
6, 7, and 8 and learned advocate for 1 and 4 to file written notes of arguments by
commercial is not.
19/8/2025. Let this matter appear on 19/8/2025 under the heading to be mentioned.
Commercial transfer. Commercial number.
Number 30 and 31.
My lord, I appear for the plaintiff decree holder, my lord. The judge examination had already commenced, my lord. 47 around questions were asked. I need a few more questions, and I'll finish.
So judgment debtor is present today. Yes.
And then I'll argue on the next day after the depositions come. I'll just finish my interrogation.
Ready.
May I begin may I?
Yes, yes.
Oh, sorry.
বসে বলতে পারি বসে আমার অপারেশন হয়েছে
Yes.
We have some problem in spinal
Okay,
cord.
okay.
So,
No. May. Mr. Lakhotia.
Sir, now
Satish Lakhotia.
This is continuation.
Yes, continuation. It was suit for eviction of leasehold premises, and judgment upon admission, one decree for eviction and occupation charges for the
Mean profits.
particular period, mean profits, and the mean profits prior to the expiry of lease was relegated to the suit. So final decree for the balance mean profits. So two execution applications. I'll submit in detail during the argument. Mr. Lakhotia, does the company have any immovable property which can be sold by the company to pay off the decretal dues?
At present, there is no immovable property.
I am drawing your attention to the audited balance sheet of the company, Mangal Rashi MAGALRASHI Stable Homes Limited. Stable Homes Limited as on 31/3/2023, 2023, which you have filed along with your affidavit of assets. Affidavit of assets would have please come to page 25. 25. 25.
25 of the affidavit.
25 affidavit which is part of the balance sheet entry current assets. Do you find from column 3 that the valuation of inventories is rupees 47,709.68?
Yes.
Now, I am showing you the auditor's report, a certified copy of auditor's report and balance sheet of Larica Infrastructure Limited for the year 31st March 2016.
I have no copy of it.
This is certified copy from the Register of Companies of the same company. দিয়ে দেবো। আজকেই দিয়ে দেবো, হয়ে যাবে।
Is it possible, Madam, without?
No, on his documents, okay. Or you are cross-examining, you are examining him on the affidavits.
He has filed a balance sheet
Yes.
particular year. I have obtained certified. He has also submitted certified copies of earlier balance sheets. I have also got copies of the same company earlier year.
You have served upon your learned friend that copy.
No, I'm asking him. I'll serve here and now. I'll serve here and now. He can.
Madam,
There's no question. At the time of argument, he'll satisfy. I'm not. I'm only asking some questions. I'm not.
Very well. Good.
Yes.
I have, can you permit me? Madam, is it permissible, Madam?
No, this is examination of judgment data, okay, not
Yes,
with regard to other evidence.
Yes.
Obviously, Madam, but
And
it
is related to the same balance company and balance sheet he filed for the year 2023. I am showing him the balance sheet for the earlier year, certified copy.
So you give a copy, okay?
Yes, I may ask the question and give it to him here and now. বসুন না, দাঁড়িয়ে থাকলে অসুবিধা নেই, বসুন। Kindly come to second last page. This is marked. Kindly come to the flag portion. Do you find under entry 12 changes under the heading changes in inventories of finished goods, work in progress and stock in trade. It's changes in inventories of finished goods, work in progress and stock in trade. Under the heading this, and again stocks at the end, what stocks at the end work in progress is valued at 47,73,968.
Yes. 47,70,968.
Do you find that the said sum, which is the value of work in progress, includes value of land in Haridevpur and Koilan amounting to rupees 5,54,805, which is referred to in the previous entry 11.
It is related to property at Pailan, not Haridevpur.
But it is here.
Haridevpur is nil.
It says it is land at Koilan, not Haridevpur. Answer is now I am handing over to you. This is balance sheet of 2016. I am handing over to you the balance sheets. I'll not be very big. Balance sheet of year 17, 18, 19, 20, 21 and 22. 5 years till 23. That's the balance sheet which you have filed. 20, 21. Kindly just see the flat portions and tell my lord whether the same figure of 47,70,968
একটা একটা করে দিচ্ছি আপনারা আপনি দেখে দেখে
47. Go look at it one by one. Say whether same figure appears against under the heading changes in inventories of finished goods, work in progress and stock in trade against work in progress. Kindly just have the look at serial number 12, the flagged portion of each balance sheet. Whether the same figure appears, just say yes or no.
Yes.
Kindly go through.
সবগুলো দেখবেন
দেখা আছে।
Yes.
Yes.
Therefore, the aforesaid sum of 47,70,968, which appears in the balance sheet which have been disclosed by you with your affidavit of evidence, includes land at Koilan. Am I correct?
Right.
Lord, should you give me 1 minute just? I am showing you the balance sheet, certified copy of balance sheet of an associate company, Kulti Townlet Homes Private Limited. Kulti Townlet Homes Private Limited for the year 31/3/2019. Do you find against entry 6 under the heading inventories that the value of assets
Entry 6.
against 6 under the heading inventories, the value of assets of the company in the form of inventories is more than 10.80 crores.
Yes.
I would tender all this after at the time of making, I'll file a supplementary affidavit by all the documents on when I make my
This
argument.
is a certified copy.
All certified copies. Therefore, from these documents, it would appear that the judgment debtor company owns substantial assets in the form of land at Haridepur and Poilar and shares in Kulti Townlet Homes Private Limited. Am I correct?
I could not understand.
So these documents show that the judgment debtor company owns substantial assets in the form of land and shares in this Kulti Townlet Hotels, Kulti Townlet Homes Private Limited. Am I correct?
This company hold only 10% shares in this company.
Can you tell what would be the value of those shares?
Now the entire property has been seized, vested by the government of West Bengal. The entire.
No, I'm saying what is the value of the share?
Value of shares will be about, I can't say like that, but
Yes, let it
100.
be recorded.
I cannot say the exact.
I cannot say.
Earlier portion also, but
Yes,
land of Kulti Townlet Homes has already been vested.
100 shares means about 10,000 rupees. 100 shares means 10,000 rupees.
Share means 10,000 rupees.
And can you tell, my lord, what will be the value of the land at Poilan, Haridepur and Poilan?
There is no land at Haridepur, and the land which is at Pailan. There is if you see the balance sheet of 2021 and 23, there are a lot of liabilities in the company.
No, question is what will be the valuation of the land? No
Value,
Judge, I have a question.
No question. The question is what is the value of the land? No question of any liabilities. You just
Okay.
say the value of the land.
land of value must be about 50 lakhs.
50 lakhs. 15, 1 5.
50, 50.
50.
Now I am showing you now. Balance sheet of Larica Estates Limited, in which you hold share. For the year ended 31/3/2022. Can you tell my lord who's Angad Lakhotia?
Angad Lakhotia is my son.
Can you also tell my lord who's Manish Lakhotia?
He is also my son.
Now, from the flagged portion of the balance sheet, you will find that you, your son Manish Lakhotia and Angad Lakhotia hold approximately 99.9% shares in this company. Can you tell my lord as to what will be the value of these shares?
Value of these shares. It is difficult to tell the value of the shares, but it can be calculated from the balance sheet.
But from this balance sheet, it appears that you and your two sons are in total control of this company. Am I correct?
Yes.
Therefore, you are in a position to arrange for funds, if required, from this company for payment of the decretal dues. Is it so? Am I right?
No. This is a separate
It will be
company.
not a fact.
Not a fact. Why, these are my questions.
This is your suggestion. That is not a fact.
That is not a fact. Very good. These are my questions. After the deposition comes, I pray for appropriate orders, including special officer, to make inventory.
So these are your cross-examination to the examination affidavit.
Yes, examination of judgment.
Yes, so these are the cross-examination.
Yes, these documents may I tender, or I tender by.
No, these are the documents of his company.
All his company.
Okay, then can be exhibited.
He exhibited. All these documents may be exhibited.
Yes.
My lord, I'll hand over the copies. It may be exhibited.
So give it
No,
way of serial.
Serial, yes.
That's all?
That's all.
Yes, record an order.
I also should get a copy of.
Yes. Please. Learned advocates for the parties are present. The judgment dated is present in court. The examination of judgment dated is complete. The judgment debtor is discharged at this stage. The documents filed be marked exhibits. Yes, fix. When do you want for arguments?
Sometime in September.
Fix. 17/9/2000.
79, another matter just has been fixed after say 21st.
18/9.
Before 17, before 17.
Before 70, I have some 8 to 12. I have some problem.
15.
15, yes.
15/9/2025 for further hearing.
There are no, these are the exhibits. Before there has no other exhibits.
তো আলাদা আলাদা করে দিন আর কি, হ্যাঁ আলাদা করলে ইয়ে তবে আচ্ছা
Collectively marked as
exhibits collectively. Okay, 15/9 for further hearing.
Fix at 2 p.m. Gupta Proceeds Limited and another.
I appear for the defendant, my lord.
Your lordship will recall, my lord, on the last occasion, my lord, we had filed written notes, but my lord, the judgments that we were relying upon were not, my lord, filed before my lord.
Oh, regarding the transfer.
Yes, my lord, transfer. So, my lord, we have prepared a comprehensive, my lord, note plus the judgments that we are relying upon. My lord, may I just show it to you? Sorry? Yes, this is on behalf of the plaintiff, and we have given the written notes.
We've received the written note from the previous.
So, the question is, you are supporting the transfer?
Yes, my lord. I am in fact praying that this honorable court, your lordship now, my lord, would not have the jurisdiction to entertain the commercial suit, inasmuch as there has been a recent judgment which has been passed on the 18th of June 2025 by this honorable court, a mention of which has been made in paragraph 4 of our written note, my lord.
So that is the last serial number 5?
No, my lord. My lord, that would be serial, my lord, that is a judgment of
I am
justice.
told, I'm sorry to
In the
interrupt
matter
my
of-
learned
sorry?
friend. I'm sorry to interrupt my learned friend. I've just been told, my lord, Mr. Chaudhary, who's leading me, is in court number 38. My lord, he's stuck.
So I shall keep it tomorrow for filing the written notes?
No, my lord, what I
The
can do
written
is,
notes
my
have
lord,
been served
may I
on us.
I have already served them written notes
2-3
days. I mean, on the last
Day
occasion.
after tomorrow for filing your written notes?
Day after tomorrow, my lord, there is
No, my lord, I have not placed the judgments as yet, my lord. I was about to place the judgments.
Do that also.
I can do that today.
It's better to do it in front of him.
But then, my lord, today and
It will
tomorrow.
not take upon considering the relevant judgments and
Yes,
your
my lord,
written
because
notes, I
it is
think
a-
order can be passed.
It is upon operation of law, my lord.
Yes,
I
so
cannot
your
do
written
anything.
notes and judgments are sufficient.
My lords, we will have to submit certain things, my lords. We are contending that the orders that have been passed
So
that
it's
are all
better
void,
if
my lord.
it
Now
is served, the written notes is served upon you. Written notes.
I have
documents.
received the written
So
notes, my
if
lord.
you can distinguish it, you make your submission day after tomorrow.
My lord, only this, my lord. Tomorrow and day after, I'll not be in town, my lord. My lord,
Because-
any time next week,
Lords, may
if
I
it is
suggest
possible.
this, my lord, subject to your lordship's
Yes.
convenience, my lord. On 18th or 19th, my lord, that entire week, my lord, Mr. Chaudhary is in some difficulty. If it commences to your lordship and my learned senior friend, could it be kept anytime after 27th of
14th
August?
you have some difficulty. 14th.
13th and 14th.
13th and 14th.
Lord,
Point.
anytime
I'll not
after
be in town, my lord.
27th August, my lord.
It is only this, my lord, that this is pure by operation of law, the thing is getting delayed.
Lords, only
There
will
is
be
a
only
judgment of the Honorable Supreme Court said that it has to be disposed within 6 months or something.
Yes, my lord. And my lord, this is
so that was
pursuant
7th
to-
April.
So if I cannot dispose it, why should I keep it just pending in this manner?
My lords, the only thing is, your lordships, we are
You collect the written notes of arguments and you place it.
we have received the written notes of
Analysis of
arguments.
these judgments are not required. You just place the written notes.
Distinguishing, my lord, we won't take more than 15-20 minutes before your lordship. Only, my lord, now that
The
Mr.
presence
Chaudhary
of
is not
Mr.
here.
Chaudhary is required. I am just keeping it on a particular day.
Yes, my lord. Great.
Otherwise, if you can submit and place the written notes, the my purpose is
Because
served.
I can submit, but my lord, I am led by Mr. Chaudhary.
Okay,
sir.
record and order. Learned advocates for the parties are present. Mr. Ghosh files written notes of arguments. Let the same be kept with the record. As copy has already been served. Notes of arguments filed by learned counsel for the defendant on or before 22/8/2025. Let this matter appear on 25/8.
My lord, 27th, my lord, Mr.
Okay, let
Chaudhary.
this matter appear on 27/8/2025 at 4 p.m.
And my lord,
Great,
may we have a copy of the written note that you
shall-
would.
we
Yes, yes, yes.
We shall serve on them.
The written notes must be exchanged.
We have
Grateful.
already given ours.
Grateful, my lord.
কি 27 তারিখে
27th.
আচ্ছা just a minute Mr. Ghosh. 27th at 3 p.m.
As your lordship.
3 p.m. Grateful, my lord.
আচ্ছা শুনুন ওই আপনি একটা ডেকে ফেলেছেন ওই 28 নম্বর ওটা অলরেডি 4টের সময় আছে ওটা আরেকবার ডাকতে হবে 4টের সময় আর ঠিক আছে আর তো কোনো ফিক্স ম্যাটার নেই এবার লিস্টটা ক্রোনোলজিক্যাল দুটো থাকবে 4টের সময়
Item number 32, action motion. Srimati Roma Mishra.
Item number 32, I'm appearing for the plaintiff, except plaintiff number 4 and 5. Your lordship, your defendant number 6 has expired on 2nd of August, your lordship. Defendant number 6 has passed away on 2nd of August.
Well, I
There is a-
9 to 14 in that case.
Substitution is required.
The substitution has to be done.
Substitution is required to be carried out, your lordship.
so
Till
how long will you take
because until unless defendant gives us the death certificate, I cannot proceed with filing
Okay,
of this
record
substitution
and order.
application. If it can be,
Learned-
if it can be out of the list with liberty to mention.
Okay, learned advocates for the parties are present. As one of the defendant has passed away, the matter stands adjourned till 4/11/2025 to take necessary steps by the plaintiff.
Lordship, it's been recorded that defendant number 6 supply us the death certificate of.
Is your fault? Defendant. This is defendant.
I am for the defendant 9 to 14, not defendant 6.
You just write a letter. He will definitely supply you.
For hearing, item number 33 and 4. Turner Morrison Limited.
Lordship, I am appearing for the defendant, Lordship, BCCL, Lordship. I am just praying for a not today, Lordship, as I am led by Mr. Bagh. He is engaged in another court, Lordship.
Okay, not today.
I am obliged.
Item number 35. Raigarh Jute Mill, Jute and Textile Mills.
Not today.
All suits. Item number 36. Indian Rayons Industries Limited.
Okay, not today.
Item number 37. Bhagavati Developers Private Limited.
Yes.
My lord, in this matter, my lord, I am appearing on behalf of the defendant number 1, A, B, and C. My lord.
I'm for the plaintiff, my lord.
Item 37. Yes, you are for the plaintiff.
Actually, the joint special officer was appointed by the court, but the income tax department imposes TDS on them. That's why they made an application.
Mr. Mojumdar is arguing this matter.
Yes, my lord. Yes, my lord. He is not here, my lord. Kindly, my lord.
So Mr. Mojumdar is to argue the matter.
Yes. And Mr. Showman Bhattacharya on behalf of the income tax.
So I'm making it not today or not this week.
My lord, keep it on fortnight, my lord. Fortnight. It will be better.
Yes. Learned advocates for the parties are present. On the prayer of learned advocate for the plaintiff, the matter stands adjourned till 26/8/2025.
Yes.
Item number 37. Sure. For that. 27.
Malad, in item number 35, your lordship, I passed it over, your lordship.
I made it just not today.
Malad, only one thing which I'll be submitting, your lordship, will kindly take it up, your lordship. I was pleased to hear the matter for a length on 2nd August, my lord.
Anyway, come tomorrow. I made it not today.
Item 38, Indian Rails and Industries Limited. Item number 38.
Okay, not today.
Item number 39, Calcutta International Club and others.
Yes. You are for?
For the plaintiff petition.
Whose application is this? GA9?
My lord, GA9 is our application.
Yes. What is this
My lord,
application?
maybe take up the GA10 first if your lord.
Yes. What is GA10?
Well, GA10 is nothing but to amendment of the cost title.
Let me see.
My lord.
GA10 আসেনি এখনো? Yes, you have a copy of GA10.
Yes.
Let me see.
Yes.
Extra copy.
Mark নেই তো এটা? My lord. My lord, I will not trouble your lordship. My lord was pleased by an order dated 18th June.
Yes.
To direct the respondents to provide us with the amendments in the name, amendment for rectification in the name of in the cost title, my lord.
No, you are the plaintiff.
Yes, my lord.
So earlier there was an order for amendment.
Yes, my lord. My lord will be pleased to turn to page 10. Internal.
Yes.
Yes, ma'am. Your lordship is pleased to direct the respondents, the advocates, to furnish us with the amendments that are required, because that was indicated by the
So
respondent.
that is furnished to you.
Yes, my lord. Yes. On page 11.
Next page, ma'am.
Mr. Goswami was has indicated the amendments.
Yes.
My lord, the amendments are
Yes.
indicated on page 8.
Yes. Where is the master summons? Let me see. Master summons এসছে কি? আসেনি? হ্যাঁ? হ্যাঁ।
copy
Okay. Let this. The matter has not come. The file has not come.
Okay.
Okay. Let it be not this week.
Very well, my lord.
এটাকে আনিয়ে নেবেন ওটাকে ফাইলটাকে।
So, my lord, fix a date.
Yes. I'm just making it not this, or shall I keep it? Let it be not this week. Acha, record an order. As the records of GA10 of 2025 is not in the file. Let GA10 of 2025 be put up on the next date fix. Register original site is requested to look into this matter.
On 20th of August.
Let this matter appear on 20th of August 2025.
Nothing in this matter, my lord. We have no objection.
Okay, 20th of August 2025.
Lord's deeply obliged.
I'm deeply.
Item number 40, Punerwala Bean Crop Limited.
Lordship, in item number 40 and 41, I am for the petitioner. Lordship, we have received partial instructions since it's an old matter. So
for the plaintiff.
Yes, Lordship, I'm for the plaintiff. Since the old matter and there have been a change in the management, they have not been able to provide full instructions. So I'm praying to keep it in monthly list of November. In that meantime, we will be able to
So
take
shall
all
I
the
keep it in
steps.
the end of September?
End of September, okay,
Okay,
Lordship.
learned advocate, Ututi Akodargun, 4041. Learned advocate for the plaintiff is present and prays for time to take necessary instruction and to cause necessary inspection of the documents. Such prayer is allowed. Let this matter appear on 18/9/2025.
18. Lordship.
ঠিক আছে তাহলে 4টের সময়। না এখন চেঞ্জ করে দিয়েছে ওই 8 নম্বর কোর্টের পেছন দিকে একটা 6 নম্বর আছে এখানে তো জাস্টিস জামির বসছেন Yes, who is appearing? Item 28.
Lordship, I appear for the plaintiff's lordship. 28.
This matter is with regard to the valuation report.
Yeah, Lordship, for the mean profit, for the determination of mean profit.
Yes,
Your Lordship.
so valuation report was under challenge.
No, Your Lordship. This is another matter. This is regarding mean profit, determination of mean profit, Your Lordship. On the last occasion, Lordship had directed us to submit a calculation sheet,
Yes.
which we had done. And the other side, the judgment debtor was supposed to submit their calculation sheet by 7th of August, which was not done. I'm led by Mr. Devdut Mukherjee.
My lord, this is my application, my lord, taking exception to the third report filed by the special referee.
No,
The
this the
suit was-
question is calculation sheet was to be filed. No, regard from the decree holder side, calculation report is filed.
Yes, my lord. But they haven't filed. They are. This is a dilatory tactics, my lord. I'm not waiting for the calculation sheet.
They have secured the amount.
They have secured the amount according to their calculations. My lord had directed them to give us their calculation, file it with the court. They haven't done it. We have written letters to them. We have written letters to them despite that they have not done it. Today they are not there. My lord will see the order sheet. At least 5 or 6 occasions, my lord, we tried doing the matter and they took adjournments. Their advocates had changed because they are, my lord, sale, they are taking advantage. That should not be, my lord. Kindly allow me to proceed with the application. Because my lord will see that the mean profit, my lord, is for the period from 2009 to 11. I have got back my property in 2011. We are now in 2025, more than 14 years have gone by and interest is accumulating. Well, that is why, my lord, we do not even want to go back to the special referee. My lord will decide here once and for all. Whatever my lord decides, we will accept that amount, we'll move on, my lord.
Yes, record an order. Learned advocate for the decree holder, petitioner is present. Learned advocate for the decree holder submits that although in terms of the direction passed by this court, calculation sheet was filed by the decree holder, but although the judgment debtor was directed to file calculation sheet by order dated 25th July 2025 on or before 7th August 2025, but the same is neither filed nor the judgment debtor is represented today by their learned advocate. Learned advocate for the decree holder submits that the matter be considered and necessary order be passed in absence of the judgment debtor. However, in the facts and circumstances upon hearing the decree holder, this court is of the view that one more opportunity should be granted to the judgment debtor to file the calculation sheet and submit with regard to the facts of the case. Thus, this matter is adjourned till 21 একটু দেখুন তো 20 বা 21 তারিখে 4টের সময় কিছু আছে কিনা
My lord, may I only request that this matter be fixed at 2 p.m. my lord, because it will take some time, my lord. If any day at 2 p.m., whichever day is convenient.
আচ্ছা 20 তারিখে দুটোর সময় আছে কিছু দুটোর সময় 19 তারিখে ছাব্বিশ তারিখে নেই 25 বা 26-এ 25 তারিখে 3টের সময় আচ্ছা 25 তারিখে কি বড় ম্যাটারটা নেই তো ওই যেটা মার্শাল হাউসের এই ম্যাটারটা এক্সিকিউশন ওই যেটা অনেকগুলো ম্যাটার আছে ওটা নেই তো 25 তারিখে তাহলে 25 তারিখে দুটোর সময় একটা আছে আচ্ছা let this matter appear on 25/9/8/2025 at 2 p.m.
I'm extremely grateful to my lord.
Yes,
My
learned
lord, I
advocate is
can't leave to Mr. Day to make one submission, my lord.
learned advocate is requested to intimate the other side by notice.
Yes.
Lordship, in this matter, an amount of 27 lakhs 47,978.25 has been already deposited. My lord, there are 3 plaintiffs, my lord. They are brothers and sisters. Now, they have issued an instructions to me to pay before the learned court that the amount we paid in the name of the brother only for their
So you come with an application. An application is required for that purpose. On the next day, come with an application, sub copy upon the other side. Yes, enclose that instruction, come with an application.
Gosh.
With this action, item number 40, Cox and others.
No, I am for the defendant, my lord. On the last occasion, my lord, as per the direction of this honorable court, my lord, the discovery inspection of documents has been done. Only the cost amount is not paid yet, my lord, but I will pay in the meantime.
5,000 rupees cost, my lord, was
It
pleased
is
to.
not paid in the meantime.
So why not paid?
Initially, it was 10,000, but my lord was pleased to judgeship court. My lord was pleased to reduce the cost amount as per their request to 5,000.
I am not offering any explanation, but I will pay. It is not paid.
That is one side to it. The other part, my lord, on 1st of July, when the matter was there, there were certain observations in regard to my submissions, my lord. What I understand, this suit perhaps should be converted to a commercial suit, if I may explain why. The claim is arising out of an immovable lease agreement of an immovable property. Now, going by the act, my lord, 217.
No, there is a division bench judgment on this issue also.
Yes. So suppose I proceed here, and knowing fully well that it should be transferred to the commercial division. Later on, if I succeed and if I get a favorable decree in my part, I won't be able to execute. Later on, they themselves will come and say, my lord, it can't be executed.
Okay.
So knowing
let me see the subject matter of the suit.
Yes, my lord.
It was my lord, suit for recovery of money simpliciter.
Very well. My lord may kindly take up my plaint once.
I was the tenant under the plaintiff, my lord, and as per the alleged, my lord, tenancy agreement, I was supposed to make payment on account of, my lord, municipal taxes.
I'm not going into all of that route or the details.
So it is a, my lord, this present suit is, my lord, for the purpose of recovery of the money, which according to the plaintiff is
But
payable
what
to
is the jural relationship, my lord? I had two of my properties, two of my flats, my lord, I had let out to them. And there was an agreement on 20th.
It was not in relation to any immovable property. This suit is only for the purpose of recovery of money that which according to them is payable to them in term on account of, my lord, corporation
KMC
tax.
dues. That is absolutely right what my learned
But
friend
not,
is
my lord,
saying.
in no stretch of imagination, if I say so, that particular liability on my part, alleged liability on my part to pay the corporation dues is to be, my lord, equated with, my lord, the dispute related to immovable property.
I'm not deciding the suit. I am just
No,
considering whether it is to be
This portion, whether
That is
commercial or non-commercial.
If, my lord, holds, my lord, that is a commercial division matter, my lord, then only, my lord, I am making the submission because I am opposing the prayer of my learned friend. In my understanding, my lord, this matter does not pertain to any issue which can fall within the, my lord.
You come ready with your written notes of argument.
My lord, may I show the act once?
Yes, yes.
It
No,
to
you
the
bring the division
I am
bench
aware
judgment.
of this.
That
But my lord, just what fallen from my lord.
Yes, yes, yes. Bring the division bench judgment.
Because
I shall
my
decide this issue.
My lord.
Very
But
well,
you
because
pay the
this
cost. You are making so many arguments, but you have not complied.
Yes, yes, yes. My lord kindly records that if my lord so
What is
pleases.
this type of attitude?
This is not done.
This
is not done.
Why so much defiant attitude of your client?
It is not a defiance, my lord. Maybe it is a mistake on my part, my lord. That is why I have not offered any explanation,
First,
my lord.
the cost was reduced by my lord. That was
Yes, record an order.
My lord, I admit it is not paid, but I will pay, my lord, before the next date. That is why
Your submission will be
no
considered. You pay the costs.
My lord.
Learned advocates for the parties are present. A learned advocate for the plaintiff submits that this is a commercial suit and should be transferred to the commercial division.
Grateful, my lord.
And learned advocate for the defendant objects the same. Let this matter appear for consideration on 19/8/2025.
My lord, one indulgence.
Yes.
I will be out of town for this thing. Can it be?
এই দেখুন তো ইয়ে তাহলে 20
Anytime later next week.
21 তারিখে 4টের সময় আছে কিছু? 21?
21 I don't know of any obligation.
আপনার অসুবিধা আছে?
না,
21 তারিখে 4টে কিছু আছে? ওকে, 21/8/2025 3টের সময়ও নেই তো কিছু?
I believe 3 will be safer.
21/8/2025 at 3 p.m. The cost which is not yet paid by the defendant be paid forthwith.
Grateful. And my lord directs that we shall bring the notes.
Yes, bring it.
Very well. Now, if my lord kindly indicates the same.
Paid by the defendant in terms of earlier order be paid forthwith.
deeply obliged, my lord.
Should my lord direct it or mention it in the order about the note?
Always liberty is always given to us, my
For the notes, because it will be conclusive in that case.
Notes of arguments may be exchanged by the parties.
So it will be done and dusted on that day. Grateful, my lord.
deeply obliged.
Order গুলো রেখো।
এটা নিয়ে নেবে ভাই।